Good morning, everybody. Got beaten to the punch there by the American colleague. Yes, good morning, everybody. Just getting underway for day 3 of hearing 5. I think that everyone that's speaking to us have had the blurb from me about the hearings and everything else, even on the Zoom coming in, so we won't repeat that. We do have one new person here that Julie has talked about health and safety matters. So welcome. Could you just stand up and introduce yourself? Yes. Conrad, welcome.
I've seen some photos of you in the submissions and evidence.
Yeah. Thank you. And just on that, we always like to start with the karakia. Would one of the gentlemen like to start with a karakia for us, or yeah, thank you. Amen. Thank you very much. So the order today is we're starting with the Department of Conservation. Ms. Yule, Ms. Yosen, and Mr. Lecoq. Are you present?
Yes, good morning. Ms. Newell here. We'll turn our camera on if we can. With me in the room is Ms. Yosen, and Mr. Lecoq is separately in the meeting.
Hello there. Welcome.
Hello.
So tell us where you're beaming in from. Is it Christchurch?
Yes, Ms. Yosen and I are in Christchurch, and Mr. Lecoq is, I presume, in Wellington or Wanganui. I'm not sure which.
Mr. Lecoq, are you there, and could you turn on your video too? Maybe he has a mute on. We'll get underway with you anyway, Ms. Newell. We have received your legal submissions. Thank you very much for those. So we'll just hand over to you to present your case. We have read everything, and as you know, just keen to get sort of a summary. And just so we've been running a certain order of questioning, but we're going to mix it up to change it up today. So in terms of questions, Commissioner Littlejohn, who is online also from Auckland, he'll start, followed by Commissioner Coffin, Commissioner McMahon, and then I'll have any final questions. So just to keep it nice and orderly. But yes, over to you, Ms. Newell. Thank you very much.
Okay, thank you. And thank you for the indication that a summary is sufficient. So on that basis, I'll point out the highlights. The main focus of the Director General's submissions on this part of the plan are the need to provide for the identification and protection of areas of significant Indigenous vegetation and habitat that may not yet have been notified through the process followed in the plan. Also to provide for the maintenance of Indigenous biological diversity, and to ensure that the biodiversity offsetting provisions reflect best practice and are consistent generally with other plans and practices around the country to the extent that is possible. Mr. Lecoq will present evidence on the ecology of the district, primarily plant ecology, and Ms. Yosen is presenting the planning evidence for the Director General. So in the statutory framework, I have briefly discussed in my submission section 6C of the Act, which talks about achieving the purpose of the Act by recognising and providing for the protection of areas of significant Indigenous vegetation and significant habitats as a matter of national importance. I've also talked about section 31(1)(b)(3) of the RMA, which makes it a function of the council to control land uses for maintenance of Indigenous biological diversity, and the requirement to give effect to the higher order planning instruments, including the New Zealand Coastal Policy Statement, which is administered by the Minister of Conservation. So the combined effect of those provisions is to provide for the protection of significant natural areas, and also to provide for the maintenance of Indigenous biodiversity generally. And SNAs in the coastal environment are addressed separately and specifically. Ms. Yosen has discussed in her evidence Policy 11 of the New Zealand Coastal Policy Statement, insofar as that those provisions are relevant to the provisions in the proposed plan. And she talks about the importance of the difference between Policy 11A and Policy 11B, which distinguishes between significant effects and avoiding effects on significant values, and how it appears that those two elements may have been conflated in the drafting of the proposed plan. Generally, in regards to protection of significant Indigenous vegetation and habitats of Indigenous fauna, we do want to acknowledge the work that's been done by the council in making a much more thorough effort to identify areas that qualify as SNAs and to verify some of those that have been disputed by landowners. However, we do want to highlight that there were limits to what could be achieved using the method, specifically by doing an assessment using aerial photographs and then ground truthing some of those areas. In my submission, it's unrealistic to expect that those methods have identified all of the sites that may qualify as significant. And I note that in his evidence for the council, Mr. Shaw has acknowledged that there were limitations, because he has carefully stated that wildlands work resulted in a relatively comprehensive layer of desktop assessment. He also notes that not all sites have been ground truthed. Those limits are also acknowledged in the Council Officer's Section 42A report, which states that all Indigenous vegetation and habitats of Indigenous fauna that might meet the significance criteria of Eco P1 may not be mapped and scheduled or otherwise legally protected. I also thought it was notable that the Section 32 report writer repeatedly refers to bush when discussing the processes for identifying SNAs. And that gives to me the overall impression that council staff may have assumed that the only significant ecosystem type in the district is the bush, and that and the council officer also stated that the bush can act as a proxy for identifying significant habitats of Indigenous fauna. And two examples that I've raised there are bats and lizards. The council officer appears to have been satisfied that significant Indigenous vegetation can safely be treated as a proxy for identifying significant habitats of Indigenous fauna, but there's no evidence to support that assumption. Instead, Dr. Herbert's evidence has confirmed that there were no surveys for Indigenous fauna, as those were out of scope of the work that she was directed to undertake. So that's direct evidence that habitats appear to have been disregarded. And I've given an example of the importance of identifying significant habitat of fauna rather than simply relying on vegetation as a proxy. And that's in the relatively recent case of Western Lee and Hamilton City Council, which was dealing with a development at Amberfield. The case was concerned with conditions that should be imposed on a subdivision consent that nobody's disputed could be granted. So the issue was really just about what conditions were required, having regard to the need to protect the habitat of critically Indigenous fauna, which was the long-tailed bat in that case. And the court confirmed that protecting the bat's habitat was to be considered as a matter of national importance in line with Section 6C of the Act. The court also expressed surprise that that habitat had not been identified as an SNA in the plan, which did identify significant Indigenous vegetation, biodiversity and habitats as SNAs. And the court considered that failure to identify bat habitat was an unfortunate oversight requiring urgent redress. Unlike the regime in the proposed New Plymouth District Plan, the Hamilton District Plan did allow for identification and protection of new SNAs as an ongoing process. So that case illustrates why the obligation in Section 6C should not be regarded as being limited to areas of significant Indigenous vegetation that the Council's been able to identify at a particular point in time, and also using the methods that have been discussed in the evidence. It's not consistent with the purpose of the Act to accept that some areas of vegetation have been recognised as significant and protected, and once that's done, there's no longer any duty to consider any remaining areas or to address changing circumstances. And one example of that Mr. Lacotte gives is where the threat status of a particular species might change. So in my submission responding to the Section 6C direction regarding matters of national importance requires plan provisions that can accommodate ongoing identification and protection of SNAs in response to new or changing information and circumstances. And that would enable the Council to respond when there are areas identified that meet the criteria for significance. The second main point is to do with the Council's function in Section 31(1)(b)(3) of the Act, which is about the Council's maintenance of Indigenous biological diversity through appropriate plan provisions. That function is not discharged once SNAs have been identified and protected. Identification and protection of SNAs may ensure that the best or most important examples of Indigenous vegetation are maintained, but there will be other vegetation and habitats that contribute to the maintenance of Indigenous biological diversity, albeit they might not reach the significance threshold under the criteria for SNAs. So potential effects on those areas and their contribution to the maintenance of Indigenous biological diversity should be able to be managed in the district plan as well. And I note regarding that point about the best or most important examples, the High Court expressed a view that the protection of biological diversity is not a relative concept concerned with only the most important or best examples. That case was about wetlands, but in my submission, the same principle applies to the maintenance of vegetation and habitats which contribute to the maintenance of Indigenous biological diversity. Ms. Yosen, in her evidence, has proposed provisions which include a limit on Indigenous vegetation clearance outside SNAs in the coastal environment. So that's essentially in the ring plain area of the district that Mr. Shaw has identified in his evidence. And that would provide a mechanism for the council to consider activities that might affect the maintenance of Indigenous biological diversity, and also to identify any as yet unidentified SNAs. In regard to the council officer's suggestion that outside of SNAs, consideration of vegetation clearance through other activities that trigger consents is adequate, I would say that that approach is likely to have a perverse outcome in that anybody planning a major project will first go and clear any Indigenous vegetation, which they could do as of right, that might be an impediment in a fully discretionary or non-complying activity consent. In regard to biodiversity offsetting, as I said earlier, the Director General's main purpose in submitting is to seek provisions and plans which are consistent with best practice. I've noted that there is a lot of commentary about the complexity of biodiversity offsetting, and cited an Environment Court decision that came out recently, which was to do with the Otago district. And I would also note that in that decision, there was a particular question about biodiversity offsetting in relation to the clearance of Kānuka and Manuka, which is at issue in this plan as well. And the court in that case noted that there are species of Kānuka that are threatened, and so Kānuka and Manuka needed to be treated differently. Finally, moving on to the Forest Act, Mr. Lecoq's evidence deals with the basis for the Director General's submission regarding the activities status for areas where Forest Act permits have been granted. And the main point there is that the test for sustainability under the Forest Act is not the same as the test for sustainability under the RMA. And in addition to that, Mr. Cock has given you several examples of where, despite having been consulted in the process of considering the sustainability of Forest Act permits, the permits were granted notwithstanding the Director General's opinion that the proposal would not be sustainable in an ecological sense. So that really concludes my legal submissions. I'm happy to answer any questions or ask Mr. Lecoq to talk to his evidence next.
Thank you, Ms. Newell. I'll just see if there's any questions. Commissioner Littlejohn.
Present. Good morning, everyone.
Morning.
Good morning, Ms. Newell. Thank you for your submissions. Just a couple of things, starting with the last item first. And I've read Mr. Lecoq's evidence, and to some extent, I think it answers the question, but I'm going to ask you directly. You've got two pieces of legislation that are acknowledged as being for different purposes. Is there any sort of derogation from grant or conflict of laws issue here, such that the government gives a Forest Acts permit with one hand, but then the local authority takes it away with the other? Has that ever been raised in one of these situations?
Not that I'm aware of, and I would submit that there isn't a derogation. I think there's multiple examples in the legislation where a particular activity might require permissions or consents under a range of different pieces of legislation. One example that springs to mind is the requirement to get building consents as well as resource consents quite often when proposing a building project. Another example that was a fairly significant one for the Department of Conservation is the requirement to get Wildlife Act permits when protected wildlife might be affected in areas where resource consents for activities have been granted. So in the case that I'm referring to is commonly known as the snails case, to do with mining in the habitat of the Pauelephanта augustus snail. Resource consents and mining permits had been granted, as well as access permits for mining on the public conservation land. And the court held that wildlife permits were also required.
Well, I mean, and to some extent that's consistent with, you know, requiring permits under the Puhuri Act as well, notwithstanding
Yes.
you've got a resource consent. And I mean, to some extent, Mr. Lecoq's evidence has the answer, because he's given examples of situations where MAF went and granted a permit, but then resource consent was refused to do it anyway. So that really does answer the question. So that's good.
Yes. Yep.
I mean, that was my only concern, that writing a rule that takes away another statutory right might have been offensive, but I'm satisfied with that now. The other one really is a general one, and it's the thrust of your case, and I think as well the case for Forest and Bird, is that the directive in section 6C to recognise and provide for the protection of significant bush is not satisfied by simply going out there, mapping and putting rules to protect around bush, because as everyone acknowledges, there may be bush, and I mean, I'm using that sense that term generically, that is not captured in that process. The council's response to date, and I did question Ms. Macbeth about this, was, well, how much do you think you've missed? And I think you've lighted upon the bit in the 42A report where there is that concession. And to be fair, their evidence was that there is a risk, but it's not great that there's areas out there. Now, you haven't called any evidence other than to refer to that concession in the 42A report about areas out there that haven't been identified. And I guess my sort of question is, do you need to? Because if the direction in section 6C is blind to whether or not you've been able to see it or not, and therefore map it, then it doesn't really make any difference. And I guess where that leads me to is that your case for a catch-all rule is sort of made out. So I just wanted to have a bit of a get some feedback from my line of thinking around that from you, to see whether you think it's sound or not.
Well, I suppose in regards to the question about the department not having called evidence of any areas that have been missed, we're in the same position as the council. We don't know what we don't know. It would be a huge exercise to try and ground truth now the entire district. And I would have to acknowledge that it's not possible for the council to do that, nor is it possible for DOC to do that. And one of the reasons, apart from the sheer scale of the work involved, is that SNAs exist on private land. And so there is a trade-off when undertaking this kind of mapping exercise for a whole district about the extent to which you can assess what's on private land. So the thrust of our case really is that there should at least be a trigger for assessments when people are applying for resource consents or when they want to do some large scale land use change that would potentially affect significant vegetation or habitats, so that the council has an opportunity to make that assessment. And that the case of the bats in the Amberfield subdivision is a good example of how that could work. So it didn't prevent consent from being granted, it just ensured that the council could discharge its obligation in that case. And the only other thing I would note is that I think everybody agrees that most of the Indigenous vegetation type in New Plymouth is bush with big trees, and aerial photographs are probably a fairly obvious way to assess where that type of bush is. But that doesn't mean to say that there aren't potentially some species that are smaller and more cryptic that might be really difficult to pick up through a review of aerial photographs. And Mr. Larcock mentioned one plant species in his evidence that only grows to about 1 metre tall. Whether the aerial photograph exercise would identify the types of habitat that small plants like that might exist in is a question that seems unanswered. So potentially places like near wetlands. I mean, I'm probably straying into Mr. Lecoq's territory here a little bit, but
I guess from a legal point of view, the key point I'd like your submission on is the absoluteness of the direction in section 6C, and whether or not it can be discharged solely by a local authority mapping its Indigenous vegetation and saying we think we've got the most of it, or is the duty such that a council is always required to have a catch-all rule to provide some degree of protection for the areas that, albeit of low risk for identification, it hasn't been able to find?
Yes, I think it's, sorry, yes, my submission is the latter. I'm not saying that there's a council of perfection, but I think that if the council closes the door to considering any further areas that qualify as significant, so it's basically saying we've done this exercise, job done, we don't need to think about it anymore. I think that the council is, it would be unable to then discharge its obligation under section 6C in changing circumstances. So
yeah, I mean, to some extent, your catch-all rule deals with the situation of what you don't know. And I mean, I suspect a plan change process deals with the situation of stuff that you don't know that you suddenly learn about that you can then add into the plan. So there's those sort of three scenarios. Okay. Well, look, that's consistent with my understanding. A similar sort of case was run by Auckland Council up here, where they said that their scheduling of SEAs, they were called, was absolute and perfect. And after 100 examples of bush that met the criteria not being identified, they conceded that they needed to have a catch-all rule. And indeed, the court said to them, you're not going to get through this by simply mapping what you know and then forgetting about the rest. So I mean, there's a strong legal and policy basis for what you're asking for. So, okay, yeah. All right. No, those I think were the only matters I wanted to chat to you about. But thank you for your submissions.
Thank you, Commissioner.
Commissioner Coffin.
Good morning. Most of my questions, I think, perhaps are for Ms. Yelson and Mr. Lecoq, but I've got a couple for you that you might be able to help with. The first one is you'd mentioned earlier in your summary, and it's mentioned a number of times throughout the submissions and also the evidence, the acknowledgement of the work that New Plymouth District Council has done, and we've received a lot of the background, and certainly for me this was new in regards to the environment court cases that have preceded the review of the district plan. And I just wondered whether you had any reflections on the work that's been done since 2015 and in light of some of the findings that were made in that decision, and whether you thought the work that New Plymouth District Council was consistent with the intentions of those findings, particularly in regards to identifying SNAs and providing for provisions around that.
I have acknowledged that there's been a lot more work done since that series of cases. My understanding of those cases was that the council's approach previously had been to, rather than taking an approach of managing SNAs through the plan, was to take an educational approach and rely on, I guess, the carrot rather than the stick, by saying that if people protected areas through conservation covenants and the like, then the council could take a very light approach to it. It seems clear to me from the court cases that the court disagreed that that approach was adequate, and my understanding is that's what's prompted the council to take this much more thorough approach to identifying SNAs. So having said that and acknowledged the work that's being done, I'm still firmly of the view that there still needs to be some mechanism for ongoing identification of significant areas, and also provision for maintenance generally, rather than just protecting the best of the best and then leaving it at that. I understand that Councillor for Forest and Bird is going to address you later today, and I'm sure that given Forest and Bird's involvement in that case, he might have more to add.
Yeah, I'm sure that will happen. Just in a similar vein, the council officers have put to us on a number of occasions that there's a suite of methods to protect or maintain Indigenous biodiversity across the district. And that includes those matters which are included in the plan and those which we might loosely call non-statutory measures. Did you have any view around the suite of the methods? Because you've mostly focused on, obviously, the district plan, objectives, policies and rules. Did you have a view in regards to the suite of mechanisms outside of the plan which have been mentioned during the hearing?
Well, I think any steps that might be taken to have a positive effect on protecting SNAs and maintaining Indigenous biological diversity are to be encouraged. I do have some concern about simply relying on conservation covenants or QE2 covenants, because they and I don't have any specific details of the terms or provisions in any covenants to talk about, but I understand that some of them might focus on protection of one particular type of species or particular element, which is not necessarily as all-encompassing as would be expected under the RMA. So I would submit that relying on covenants alone doesn't address the obligation under section 6C and 31(1)(b)(3) of the Act. Although they do definitely have some good outcomes for both landowners and for the protection of those areas. There's a little bit of overlap with the question that Commissioner Littlejohn asked me earlier, which was regarding the Forest Act permits and the RMA, and that was if you've complied with one provision, do you have to comply with all the others? I think the answer in regard to conservation covenants and QE2 covenants is the same. The fact that there is a QE2 covenant doesn't necessarily mean that the plan should ignore an area that qualifies with the criteria under the plan. And there is another significant difference, which is the monitoring and enforcement provisions that would apply. So I'm aware that there was a case where a QE2 covenant had been breached a few years ago, and for action to be taken in respect of that breach was retrospective, very onerous. It involved, I think, 3 or 4 trips to the court, up and down the court system. And the solutions were a lot more limited than the range of enforcement options available to the council under the RMA, which includes a full suite of abatement notices, enforcement orders, warning letters, and prosecution if nothing else works. So I think that the options for managing non-compliance are much more tailored under the RMA than they are in the case of covenants.
Just writing some notes there. Thank you for that. Just changing tack slightly, just within the context of the district plan and knowing that they get reviewed every 10 years. So there's each decade there's an opportunity to update and review the plan, including the schedules of SNAs and learnings from those. Within that context, my question is it Doc's submission that more work needs to be done, or will the provisions that Ms. Yelson has suggested in terms of this as regards to the vegetation clearance outside of the coastal environment area would be sufficient to meet to meet those obligations which you've set out in your legal submissions?
I'm not sure if I've understood the question correctly. Are you saying would it be adequate in the next plan review to add any extra SNAs that might have been identified in the interim?
Yeah, it was a bit of it's a catch-all question. I was trying to keep it broad, and it probably was too broad. I was thinking about the Doc's submission in terms of those areas which have not been identified as SNAs, but potentially could meet the criteria, particularly those areas outside of the coastal environment area. And there's been, Ms. Johnson has put forward some suggested provisions which may be able to capture that. And I was thinking, is that the approach in the department's view addresses the issues in regards to, particularly those matters in regards to capturing all of Indigenous biodiversity, or do you think more work needs to be done in this 10-year period?
So the approach is really to ensure that during the 10-year period, in significant Indigenous biodiversity and non-significant biodiversity that needs to be maintained, yes, can be identified and dealt with appropriately as and when necessary. So possibly it might be helpful if Ms. Yosen addresses that point more comprehensively.
That's fine. Thank you.
Thanks.
Commissioner McMahon.
Thank you, sir. Good morning, Ms. Newell. You can hear me all right?
Yes, I can. Good.
I just want to focus on the identification and protection of significant Indigenous vegetation. And my first question relates to, I guess, the statutory framework that you've usefully outlined in your section, paragraphs 7 and 8. And you've directed us to section 6C and the functions under section 31 that give the council the jurisdiction to implement section 6C. And then in terms of the higher order documents, you referred to the New Zealand Coastal Policy Statement and the RPS. What you're silent on, and I think I know the answer, but I need to ask it, is the status or otherwise of the draft MPS and IB. And the fact that you haven't mentioned it, is it as simple as the fact that it has no legal status, it doesn't exist, and therefore it's not on the table?
To be honest, as far as I'm aware, it is still in draft. And I don't know how significant any changes might be or what they might do. So I was reluctant to go there.
It's not a criticism. I'm just wanting to know from your legal perspective whether it's on the table or not.
Well, I would say at the very least it's one of the other documents that can be had regard to as a relevant matter, but I think the question is about the weight to be given to it.
Oh no, not so much the weight, it's more whether it has legal effect and whether it's something that has to be given effect to as opposed to having regard to. I mean, the document, the draft document, there's no certainty as to what its final provisions will contain. There's some thought, some suggestion that it may be available later in the year, although we heard yesterday that might be in doubt, and there may be another iteration of a draft exposure document given, albeit selectively to stakeholders. So I guess what I'm asking is it in the tent or not?
I think the best I can say is that it is in the tent, but it's very much in a back corner.
Okay, right, yeah. Thank you. That's probably as far as we can take that one. The other higher order document, we heard yesterday from Port Taranaki about the proposed coastal plan. And
Yes.
I presume there's a decisions version of that now, which has legal effect. And I just wonder what weight or what relevance that is as far as it defines the coastal environment and the inland extent of that might impinge on this district.
Yes, and that's always a difficult question to answer, the extent, because under the New Zealand Coastal Policy Statement as well, there is a case to be made that the coastal environment it's an area wherever there are attributes that relate to the coast. So it can be a very difficult to define thing. And I'm afraid I haven't considered directly that question that you've asked, so I'm reluctant to give you any firm answer on that one either.
Yes, okay. Well, we may have to take it up further with the officers. What I'm trying to ascertain is just what relevance it has, if any, and what the test is. Can you recall whether district plans have to have regard to or give effect to regional plans?
It's to have regard to.
To have regard to, thank you. And that would include a proposed regional plan, presumably?
Yes.
Yes, okay, thank you. So I guess, Ms. Macbeth, if you could just address that in your right of reply, that would be appreciated.
Yes.
Thank you. Ms. Newell, my second level of question is about the resource. And you started your submissions about acknowledging the work that the District Council have done, as have had many submitters acknowledge the work. And you talked about bush, and I'm using the term bush because you did, and so did Commissioner Littlejohn, being a proxy for Indigenous vegetation, and then Indigenous vegetation being a proxy for fauna. And I understand the argument that you're raising, that there's quite a few assumptions built into those proxy considerations. But in the absence of undertaking a full survey of fauna in the district, that's what we're left with, isn't it? Using Indigenous vegetation identification as a proxy for that part of the biodiversity resource.
Well, what I was trying to convey in my submissions is that there's no mechanism in the plan to account for some areas having been missed, and what we're proposing is a threshold for permitted Indigenous vegetation clearance, which would act as a trigger.
Yes, I understand that, and I'm going to come on to that in a minute, but I was more worried about whether you were making a distinction between the plan reasonably well identifying Indigenous vegetation, the flora component, as opposed to the fauna component.
Well, yes. So it does appear from the council's documents that I've looked at that there hasn't been any work done to identify any significant habitats of Indigenous fauna. So
what's the Director General's position there? What do we make of that?
So I guess that there are, I've already acknowledged that it's unrealistic to do a very detailed ground truthing exercise of the entire district, and the alternative, if that's beyond the capability and the means of council to do, is to have provisions in the plan that enable areas to be addressed when activities are proposed that might have adverse effects on them.
Okay. And the Director General hasn't sought any particular relief other than the relief that you just mentioned earlier about a new activity status for the clearance of Indigenous vegetation outside the coastal environment and outside SNAs.
No, and part of the reason for that is that we also don't know what we don't know about habitats of fauna. And I did specifically mention bats, and I'm aware of a couple of examples around the country where new bat colonies have been identified where nobody thought there were any in the past. And they've been identified as a result of work being done.
Yes.
In the context of large development proposals. So really, if the plan has provisions to acknowledge that once such things have been identified, then or locations of things like that have been identified, then they can be recognised as SNAs. That enables decision makers to make appropriate decisions. Okay.
Right, my third area of questioning is around the new rule that you're seeking. But just before I get to that, I just wanted to ask you a question in response to your answer to Commissioner Coffin regarding SNAs versus non-statutory protections. Well, covenants, whether they're QE2, Conservation or Reserve Act covenants. And I wrote down that your answer, which you said that that non-statutory approach doesn't meet the Section 6C obligation to protect significant Indigenous vegetation. And I just wanted to test you on that, in the sense that I had always thought that the councils had a discretion to determine what was the most appropriate mechanism, method, rule, policy to give effect to the objectives and relating to Indigenous vegetation and the Act itself. And if they chose one mechanism over the other, so long as they could justify it, then that would stand the Section 32 test. And I think you're suggesting something else in that sense.
So I really was bearing in mind the previous decisions on the New Plymouth District Plan, where the court said that yes, a palette or a range of measures was available to the council, various different methods, but then there becomes a practical question about how effective it is to rely on one of those measures or another. And my understanding of that series of decisions was that simply relying on mechanisms like covenanting did not mean that the council was discharging its obligations under Section 6C.
And that's your position?
Yes.
Okay, because we've heard during the last 2.5 days that there's a desire from the Section 42A officers not to duplicate provisions, and that they don't see that as being effective and efficient in a Section 32 context. And so what we've seen is recommendations that where parts of SNAs are covered by a covenant, either fully or total, that's a basis for deleting or not including the land as an SNA. We also heard yesterday about a situation where there's a comprehensive biodiversity management plan in place for a significant area of bush, and that is seen as being, by the officers, as being sufficient to meet the obligations under Section 6C without a SNA designation over it. And so I guess what I'm saying is that there's been an intentional mix and match approach in the officers' recommendations to discharge their responsibilities under Section 6C. And firstly, I wasn't sure whether you were aware of that, and secondly, what your view of that was from a legal point of view.
Yes, I had picked up that there was a mix and match approach, and in my submission that the district plan would function more effectively if it applied tests within the plan. And I go back to the answer I gave before about the downstream way in which the council then has to manage areas that are significant, and the lack of enforcement and compliance options under those other mechanisms as opposed to the SNA. So my understanding is that under a QE2 covenant, it's the QE2 trust that has to take enforcement action in the case of non-compliance rather than the council, for example.
Right. What we're hearing is that there's an incredible amount of enthusiasm in the district to protect the resource, and that the take-up of these covenants has been one of the highest in the country. And so for people to actually make the effort to put the covenant in place and negotiate the terms, wouldn't that give the Director General some comfort that there's a real intent to protect the resource in that instance, and that will be in perpetuity?
Yes, and I did acknowledge that those positive approaches to protecting areas are also to be encouraged. And my understanding is that there are rebates that apply to covenant areas, which might also act as an encouragement. So I'm not suggesting that is a bad thing at all. I think that is to be encouraged, but I would also submit that there are obligations in the plan, and what I'm seeking to suggest is that the council has to leave open to itself the options in the case where there might be a less enthusiastic approach or take up of some of those other options, or you might also imagine a scenario where a QE2 covenant is on land that's sold to a future owner who is not so enthusiastic about that mechanism and has a different approach to the previous owner to compliance. So
yes, I mean, I was suggesting that the covenant would be in perpetuity And there would be a buyer beware approach too at the time of purchase.
Yes, yes, that's correct. They usually are in perpetuity and rely on the QE2 Trust for enforcement.
Okay, right. And just to round this one off, the Director General hasn't taken a position through further submissions on particular submitters who have sought to use the covenant approach as opposed to SNA, has it?
No, no, we haven't taken a focused approach on any particular areas. Partly that's because given those areas are mostly on private land, it's difficult for us to know about the details of them. But also because we're really focused on the overall scheme of the plan and the way it works.
Sure. And that takes me to my very last question, and it's probably the nub of your issue, and that's the catch-all rule, if we want to call it, the disturbance of vegetation not identified, not within the CE or not within SNAs. And I just want to explore the concept of risk, and particularly in the Section 32 context about the risk of acting and not acting. And so it seems to me, Ms. Newell, that this is a classic example of what Section 32 contemplated, that there's imperfect information about the nature of the resource. And therefore, when the council are deciding how to approach that, they have to give some consideration to the risk of not having rules or the risk of having rules and the costs and benefits associated with those. And in this case, risk could be perhaps informed by a number of things. Firstly, the spatial area that's at risk. So would you agree, firstly, that the spatial area is really the area between the eastern boundary of the coastal environment and the eastern boundary of the district, i.e. the area between the inland boundary of the coastal area and the boundary of the district, because there are rules within the coastal environment that don't relate to SNAs, and there are SNA rules in the coastal environment, and I'm assuming you're satisfied with those rules. So the area of risk relates to whatever that spatial area outside of those areas.
That's the main focus. So yes. I think one of the witnesses mentioned the ring plain, which is the flat land that has been largely cleared and is now classified. Mr. Lecoq can probably give you the correct terminology, but under the Land Environments New Zealand classification, I think it's one of the most at risk or the most highly threatened areas of land environment types because of the extensive.
Yes, and we'll have some questions. We have some questions to Mr. Lecoq on that, but you'd agree that that's the spatial unit that's most at risk.
The primary area. So we did have some concerns about the rules in the coastal area regarding that hierarchy between policies 11A and 11B in the New Zealand Coastal Policy Statement, but it's the absence of any mechanism in the plan in the remainder of that area that you've described.
Yes, and that's a nice segue into my next part of this question, and that is there a complete absence of any mechanism? Because Ms. McGrath suggested that whilst there are not rules in that unit that we're talking about, there are policies that would apply should resource consents be necessary, and the trigger for assessment, for a policy assessment, obviously would be whether there's a resource consent, land use or subdivision. And you talked earlier about large-scale clearances of earthworks and large-scale activities that could impact on the resource. I'm going to suggest to you that those sort of activities would be captured by a consenting process, which then would allow the council to apply policies, some of the policies when considering subdivision and land uses. So I guess what I'm suggesting to you is that there's not a complete absence of control in that that area outside of the coastal environment, but it's certainly not a direct rule.
Well, I have to disagree with you there because I mentioned briefly in my submissions that if I were a developer planning to do some activity that required a resource consent, be it discretionary or non-complying, and I was aware that there was some Indigenous vegetation or some fauna on the land that might be relevant to those policies that you've mentioned, the first thing I would do is get rid of it before I apply for a resource consent.
That wasn't the question. The question was, that's the so what question. Answer. The question is, what is there a policy framework that would be in place if resource consent, such as subdivision and land use, were lodged that affected Indigenous vegetation? Whether there was some disingenuous approach to that is another matter.
So the policies are there. Whether or not they would be applicable in any given consent, I think is too speculative for me to talk about. But my submission was that is, given the absence of any mechanism to prevent that calculated approach that I've described, I think the policies are going to be ineffective.
Okay. Given that we don't know what we don't know, I mean, how do the panel get a handle on the risk of not acting, the risk of not adopting the Director General's relief, the risk of adopting the recommendation of the 42A officer? How do we get a handle on what that risk is in relative terms?
Are you asking me what will be lost without the provisions? If that seems to be the question, and the answer is that we don't know.
You don't know.
And that's the point.
And I guess what I'm saying is that sufficient to include an extra layer of regulation, given the impetus of Section 32 about only acting if the risk is warranted?
In my submission, yes, that is sufficient, and that's because the Act says that it is a matter of national importance to protect SNAs. That applies whether you know they exist or they don't, or you don't know they exist. And it's also a function of the council to maintain Indigenous biological diversity. And again, that function exists whether you know something exists or it doesn't.
Yes.
So the Act doesn't allow for turning a blind eye to the things that you aren't aware of.
No, but the Act requires us to have some cognizance of the costs and benefits associated with that regulation.
And my submission is that an appropriate balance of the cost and benefits requires that there be some sort of trigger or some sort of mechanism for assessing what might be lost.
Yes,
otherwise the costs of the loss are too high.
Sure. And has Ms. Yosen conducted a Section 32 assessment along those lines?
She'll have to answer you on that when she comes to discuss her evidence.
Thank you. Thank you for your answers. Appreciated.
Thank you.
Thank you, Ms. Newell. You've certainly been through the mill with lots of questions, and I just want to confirm that we're finding this very, very helpful. This is a key matter for the district. The full panel is hearing these matters. There's a high level of interest around the country and in this district on these matters, as you'll be aware.
Very aware, thank you.
And as a decision maker, I really value submissions from legal practitioners, experienced practitioners, because just the way lawyers look at things and set them out, I find very, very helpful in terms of decision making. So just like to thank you. And your submissions, clearly written, easy to understand. So just really want to acknowledge your work there. I do have just a final few clarification questions for you. The first one is about the biodiversity discussion paper 2018 that's referenced in Ms. Yosen's evidence. And it's a bit like the question around a draft NPS, its status and decision making. You said that the draft NPS was way back in the corner of the tent. I have to acknowledge that I think it's probably outside the tent, but that's just a different approach. That guidance document, along with all guidance documents issued by government departments, are we required as decision makers to follow those, give effect to, have regard to? There is quite a unlimited list of matters that we can really go to, and that does include evidence where people can cite these things. So I just want to get your advice about that document that hasn't been through any public consultation process. It's a guidance document as I understand it. So just give us some submissions on that point, please.
Yes, I think that the relevant point is that it is a guidance document. It's not a document that has any legal effect. It might be interesting. It's probably something that you can consider and put to one side. It might be useful, but it's not in that tent of things that are a mandatory requirement that have to be given effect to or be consistent with or had regard to, like the hierarchy of planning instruments. Yes, the range of guidance documents that's out there is potentially massive. So,
yes.
And in my submissions, I haven't referred to them or put any notes.
That's right.
Because I don't think that they're of particular use to you or particularly helpful to you.
Yes, but would you agree that we're an expert, perhaps been involved in those or their own experience? Those guidance documents can come to us for evidence as useful information.
Yes, and we have referred to the biodiversity offsetting guidance, which I have submitted is useful to you, and that's mainly because, as I said in my submissions, the biodiversity offsetting is really complex and difficult, and my own view is that the guidance is useful and helpful, and its DOC's purpose in submitting specifically on biodiversity offsetting in plans when they come up is to try and help ensure that there's consistency around the country, so there is less confusion and less misunderstanding about how biodiversity offsetting should work best. But having said that, I acknowledge it's only guidance, but my submission is that in the case of that guidance, it's very helpful.
Thank you for that. In being one that's had a lot of experience in this field, both in a decision making and representing applicants, I do acknowledge it's a very difficult area, great intentions, but quite tricky to work through and get right. So I appreciate that. My next question is about offsetting versus compensation. And this is something that is raised by Ms. Yosen, but from a legal perspective, with the new provisions introduced in 2017 for both policymakers and decision makers associated with resource consents, in a legal sense, is there a hierarchy between offsetting and compensation, or are they oars
Yes, I would submit that there is. And this is relying on the guidance about biodiversity offsetting. So the hierarchy is avoid, remedy, mitigate. And then my submission is that offsetting is to deal with any residual adverse effects that can't be avoided, remedied and mitigated, but there are limits to offsetting such that it should be like to like, and it's got to achieve no net loss and preferably a net gain. Compensation, on the other hand, is more to be regarded as a benefit that can be considered a positive effect. So it doesn't really have the effect of addressing the specific negative effects of an activity, but it can be taken into account as a positive effect. So it's really a last resort. And I think applicants usually try to use it to shift the overall balance of decision making in their favour.
That may be in the guidance, but is that what the Act says?
Yeah, the new provisions in the Act I see do refer to offsetting and compensation in the same clause, same phrase.
So what is your submission to us on that direct question? Is there a hierarchy in the Act, or has a hierarchy been established by the courts and case law to date?
My submission is that the hierarchy has been established by case law.
Okay.
I don't think the Act attempts to deal with the difference in enough detail to really understand it in as much detail as going to be required by any decision makers. So I think the case law has to be relied on there.
And is that case law post 2017 or prior, or both?
I haven't found any case law post 17. The Otago series that I referred to, I think because the proposal was prior to the amendments, I think the court had to consider it on the basis of the legislation at the time the proposal was made. So
right.
I'm sorry, I haven't got a better answer to that for you, but I would be happy to do some more research and respond to that question specifically.
Yes, that would be very helpful. If you could just do some research and just file an updated note to us through the hearing administrators.
Yes,
thank
I'll
you.
do that.
Look, my final question, it's more of a comment. There is no section 32AA analysis in Ms. Yosen's evidence as I can see it. Is that right, Ms. Yosen?
You're correct, yeah.
Yes. And the hearing procedures have requested that. Otherwise, we've got to try and make it up without evidence. So neither the Director General or Forest and Bird contending for these reasonably significant changes have provided us with any section 32 type analysis on the costs and benefits. So I just like to signal, I see that as quite a problem. So we can address that with you, Ms. Yosen, and find out what we can just through direct questions on that. But just wanted to signal that that's certainly an issue for me. So this probably doesn't require a response, but if you had any comment on that, Ms. Newell?
Yeah, I acknowledge that it would be helpful if we would be able to do that. I am sorry. Okay. Yeah, Ms. Yosen has just said to me that she would also be willing to attempt to do it, and something further.
I think that's an imperative for us. So I would feel that that is important, and haven't discussed it with the panel, but I'm sure we'd all appreciate some analysis along those lines, particularly following up from the questions from Commissioner McMahon. So we can, if that can be some homework as well.
Okay.
And I'm thinking on both those matters, we are hearing back verbally from the 42A reporters next Tuesday. And it would be helpful if it was all possible to have something in by Monday next week on the 32AA. Is that possible?
Yes, we should be able to do that. Yes.
Thank you. Thank you very much.
Apologies, just to clarify, is that only covering the generic vegetation clearance rule?
No,
or
I
the
think,
biodiversity compensation?
yes, I think where you're seeking a change, it needs to be, and for us to make a change to a proposed plan, we've got to be satisfied that the 32AA matters have been addressed in our decision making. And as I say, we rely on evidence, particularly from expert planners in regard to that.
So just to be clear, that is to cover biodiversity compensation offsetting Indigenous vegetation clearance rule and the SNA identification?
Yes, the changes that you're seeking in your red line. Thank you. It's been quite a long session, but I don't apologise for that, because this is very important, and I'd just like to just reconfirm our thanks to the Director General and the team there for the help. But we'll get on to the evidence now, if that's okay.
Thank you, and thank you. Appreciate your thorough approach as well. So I'll ask Mr. Lecoq to speak to you next. Hopefully he can turn himself on.
Miss,
is that better?
that's good. Can we see your face as well? Is that possible?
I hope so. I'm up there. No?
Oh, there you are.
There am I. Yeah.
Yeah. Welcome, Mr. Lecoq.
Thank you very much. My full name is Graham Dennis Lecoq. I've been employed at the Department of Conservation for 24 years. I've held my current role as a technical advisor ecology for the past 9 years. I'm actually sitting at home in Tawa. Previously, I was a technical support officer, Flora in Docks, Tongariro, Whanganui, Taranaki Conservancy for 15 years. Before working for DOC, I worked in South Africa for 10 years as a scientist for a conservation agency, and for 4 years as a technician with an ornithological institute concentrating on seabird research.
Mr. Lecoq, can I just interrupt? We have all read your evidence.
Okay, good.
We are looking pretty much for a highlights package from you, just focusing on the key points. So if you could just take us through in a summary perspective, that would be great.
Okay. So the key points. There was some question around the definition of indigenous vegetation. The proposal means flora that are native to New Zealand. Director General submission sought an expansion of the definition to include vascular and non-vascular plants. I didn't believe that was necessary. I took flora to include vascular and non-vascular plants in a sort of layman's sense. Apparently not the best in legal terms, but for a botanist, it's, I think, flora to the public is everything, includes your bryophytes and fungi and lichens and so on. Significant natural areas. Again, like many other people, I commended the council and Wildens on the approach they took to the identification of the SNAs. where I think the critical point was the ability of the public to question things and request a visit, so that you had that check. I've been through other councils where they didn't have that option, and it wasn't very good. So yeah, I mean, I recognize that the identification of SNAs was largely a desktop exercise, and there was some ground truthing. It's not going to be ideal. There will be sites missed, and I think Mr. Shaw acknowledges that. I think if you look at Mount Messenger, when that proposal went through, they poured a whole lot of effort into identifying issues there, and it turned up all sorts of things like weather bats and lizards and so on. So, but you don't expect that for identifying SNAs. So yeah, new sites, new populations may be discovered. A lot of my examples are coastal, like a new plant turned up at Stent Road that hadn't been there before. I know it's outside your district, but it's just an example of things that do happen. It was only known from South Island, being extinct from the North Island for about 100 years. It turned up, botanist found it, but it's those serendipitous discoveries do happen. And then there's also the threat status, which changes between the 2012, 2017 assessments for plants. There were 61 additional plants were raised as their threat status increased, so they were more at risk. One of these, Scandia rosifolia, Bill Clarkson, I don't know if you know him, has been doing a lot of work with school kids around this one out on the coast. Yeah, so status does change of these plants. The other thing was the vegetation clearance authorized under the Forests Act. I've spent a lot of time working in this field when I was in Wanganui Conservancy, covered about 200, 250 applications there. The sort of inland Wanganui, Taranaki forest was getting the most permit applications in the country. So I've highlighted 3 examples there of where the RMA required some oversight. So the department gets consulted on all applications. It's part of the Act. The department's consulted on every application, and we respond. The MPI, or Te Ururako as they are now, are looking at the sustainability of the resource, not the habitat. So one of the examples was, what was it? It was the New Plymouth district. It was for a plan, so it's a 50-year plan. There's a major bat habitat, but because they had a good timber resource, and Te Ururaka or MAF at that stage didn't need to consider the bats, they allowed the logging. So that's my concern, is that the approval of a logging permit, a logging plan, doesn't take the habitat and the values of the habitat into account. So that was the thrust of my evidence on that one. So yeah, that's the main points I wanted to raise.
Thank you, Mr. Lecoq. We may have some questions.
I'm sure you have.
Yeah. We'll start with Commissioner Littlejohn, please.
Good morning, still morning.
Good morning.
how's this? Where you're in Tawa, I'm in Auckland, and we're connecting via New Plymouth. How's that for a modern world? I just had one question. Your scope of evidence suggests at paragraph 11b that you're going to give some evidence as to the criteria to be applied when assessing whether an area is an SNA, but I don't find any evidence about that follows. Is that an oversight, or is that just a subject indication that didn't carry through into the evidence?
So that you're talking about?
The criteria for
Area.
SNAs. You say it's in your paragraph 11b. You said you were asked to give evidence about various matters, including the criteria to be applied, and I couldn't find anything in particular where you get into that.
Ah, okay.
Well, look, if
it's
it's just
I
something you
mean,
didn't.
for me, the Shaw's evidence cover that. So they're looking at at rarity. They're looking at site records, rarity, looking at all reports. So they're doing due diligence on every site and on every report. They're looking at databases.
Okay.
So yeah, I didn't go into details.
The only reason I ask is that one of the matters in contention that Forest and Bird raise is the drafting of that particular policy, which sets out the criteria for determining SNAs. It's policy Eco P1, and the claim or the suggestion in their submission is that they need to be more fulsome. And Mr. Shaw has responded to that in the council evidence, and Forest and Bird rely heavily on your evidence, but I have understood from the answer you just gave me that you're comfortable with the approach that Mr. Shaw has taken with respect to criteria.
Yeah, you're talking about the sustainability criteria?
No, I'm talking about policy Eco P1, which are the factors that go into determining whether an area of vegetation is significant under the RMA. Representativeness, rarity, those, the four factors. And yeah.
That's right, yes. Doc has done some work around that. Shona Myers, also often a commissioner, as one of the co-authors on the Doc guidelines, which followed some of Shaw's guidelines.
Well, Ms. Myers or Commissioner Myers is not giving evidence, Mr. Lecoq.
No, I'm just saying.
It's not a criticism. Yeah. If you don't have any specific evidence about the criteria and your references to Mr. Shaw's evidence, then you've answered the question, and that's where we can leave it if need be.
Yeah, he's proposed the proposed Indigenous biodiversity policy as the criteria to be followed, which are similar to his. There are a lot of similarities, but so and those would have come from the build up through years. I mean, there's a lot of case law about what needs to be looked at.
Yep. Okay. So, and I'm well familiar with it. So
okay.
I think that was the only matter I just wanted to ask you about. I appreciated your evidence of examples around conflicts between the Forests Act permits and the Resource Management Act. That was very helpful. Some very interesting case studies. Really, you get the sense that MAF, or under its new name, appears to be quite happy to allow timber to be taken out of forests, regardless of its status. I mean, it seems a little bit concerning, but look, Ministry for Fisheries also allows various things to happen in the oceans that a lot of people don't like either. So I guess it just represents the conflict within any government that has a huge natural resource base. So I appreciate those examples. They were very helpful. Thank you, Mr. Lecoq.
Thank you.
Commissioner Coffin.
Good morning, Mr. Lecoq.
Good morning.
Just in a similar vein, I've got a few questions. The first one's just very similar to Commissioner Littlejohn. And so I've taken it that you're comfortable with the methodology undertaken by Wildlands.
Yes, I am. Yeah, it's thorough. For what it is, it is a thorough process, and I wouldn't expect them to be going out surveying the country.
And supplementary to that, are you comfortable with the work that's been undertaken, including the ground truthing, understanding there is some timing, resourcing limitations?
Yes. Yeah, it's an overview, and a lot of it's to do with the boundaries and so on, and all specific issues. And yeah, so I think the ground truthing was a significant exercise. They changed the boundaries or changed the SNAs in a lot of those cases. So I think it was a really important component of the whole process.
Next set of questions, and we're getting into the detail of what's missing. So legal counsel, you don't know what you don't know, but I suppose with the Department of Conservation, you're their expert, and I wouldn't mind getting your thoughts on what you think might be missing, what might be unknown. And you gave the Mount Messenger example. I thought that was a good one, and I just wondered if there's been any analysis done of. There's the areas which have been identified in SNAs, and there's some numbers around the number of hectares that includes, and you'll know with your experience with the Department of Conservation estate, and in the areas that are sitting outside of that, with your experience across the wide region, do you have an idea of the scale or the types of habitats you think are missing, other than those which you've identified in your evidence?
I'm not saying anything is missing. What I'm saying is that sometimes you do come across stuff that hasn't been found before. We about 15 years ago, we came across a herb field at the Opunaki sewage works. It's outside your district, I know, but we hadn't known about it. It was a magnificent herb field, and there are things like that you're not going to pick up from aerial imagery, but word of mouth or being in the area and saying, "Oh, that looks interesting. Let's have another look at it." And when people are out there, they find that kind of thing. If you think of some of your plants, Mimi Scenic Reserve, is that part of you? Brachyglottis turneri, it's a really threatened plant. That's hanging on the cliffs there. Found it at the Road and Forgotten Highway along the roadside. So there are these discoveries being made, and they are not going to be picked up through an SNA process. Once the stuff is known and it gets into the sort of public record, or our naturalist or the databases that Wildlands have access to, then it's known, but it's not, we don't know everything. If you look at lizards, you're looking at a sort of 3-month survey to find stuff. So Mount Messenger brought stuff to light, but you're not going to apply that effort to everything. I think the important thing is the linkages, the little patches of forest or the big tree or whatever leading down to the coast. Finding now that bittern are moving all over the countryside. So even your little small farm wetland is becoming important. So it's these new discoveries, new research that does raise issues and raise the value of sites. There's a lot of management of sites going on now. So your especially around on the fauna side, they're going to be spreading out. Your birds are going to be recovering and using habitats. So yeah, but we don't know where everything is.
So in your view, notwithstanding that there may be new discoveries as continuing work goes on, the resource consent process under the RMA is the most appropriate and relevant way of being able to, I suppose, identify and assess that Indigenous biodiversity as it comes up in consent processes?
It is a significant resource of information, and a lot of your best work is done at that level.
I just had another question about the ground truthing. In your experience, do you see, as a result of ground truthing, that SNAs tend to be smaller or larger? And I just asked the question, as my experience in the Rotorua district was where ground truthing occurred, you did have some areas where actually the spatial extent it ended up being larger on the ground, but in most cases it was actually a smaller area, a more defined area.
I haven't had a lot of experience with it. I know when we looked at the Kapiti Coast district, people had issues where their driveway, which had trees overhanging it, was suddenly an SNA. So I think in this one, a lot of areas were taken out of the SNAs. I'm sure if the boundary showed that, or the site visit showed that a river or gully or something was valuable, they'd consider it. But generally, it's people that are raising the issues are saying, I don't like this on my patch, or I'm concerned about the boundaries. So it's the kind of issue that's raised, I think, drives the re-evaluation.
Bats been, Legal Counsel raised the issue about bat habitat, and I know there's been a lot learnt in the last few years, and it's been a little while since I've read evidence on bats, but in the new Plymouth context, are you able to give a short summary of where you're likely to find bats based on the most recent information?
Oh, I don't claim to be a bat expert, I'm sorry. I know it did come to light in the Mount Messenger area. They're moving around, so that's the problem. They roost on one side and then they roost in another side. It changes. Tikawiti is King Country is a big focus, and that'll be stretching through into the Taranaki forests. But where they are, I don't know. The one site was the forestry one I referred to. Let me just find that bit of paper. That was on your northern or your western boundary. Mohokatino Paraninihi Wandi East Trust. So it was that land. I don't know if you know it. Out to the so that's where you had the beech trees and the bat passage, long-tailed bats. So yeah, but yeah, it's through that forestry country, obviously, but I can't tell you exactly where or how many.
Thank you.
I can find out for you if you'd like.
That's probably fine. I just wanted to get your view because issues raised, and your docs expert in this particular case, and whether there was any. Like I've seen the Mount Messenger material, and I just wondered whether just how that might apply to the rest of the district, because that was quite specific to a specific area.
Yeah, I think what that brought to light is that those intensive surveys do turn up stuff. So if you apply the same intensity to the next valley along, you have a very good chance of finding similar results. It's good country, you know.
Yeah. So thank you for that. I just got one last question, and it's something I didn't see specifically in your evidence, but it's a matter that the Department of Conservation is raised, and this is regards Kānuka and Manuka, and my layman's view of it is a little bit rudimentary, and it seems to me that Kānuka and Manuka have ended up in an unusual situation where because there were use rights that may not have been undertaken for a particular point in time, that Kānuka and Manuka becomes a second-class citizen in regards to Indigenous biodiversity, and then perhaps has been treated like a crop, particularly in regards to honey. So I just wondered whether you had a particular view on those two species individually, because they've been lumped together as Kānuka and Manuka.
Yes. My view on them. I suppose for me, it's I was trying to look at the sort of pragmatic approach where if you've got a paddock that has had a bit of regen on it, I personally was sort of looking at, I'd probably be on the side of saying that's regeneration, and it's part of your management regime of that site is to clear it. But the clearance rule didn't go to existing old stand stuff, or slips that happened in Manuka or Kānuka, where the sort of first crop to come in. It doesn't cover that. But where it's been farmland, yeah, I suppose I'm probably being a bit pragmatic in saying, yes, it's probably suitable to clear it. I recognize that it's very good for there's a lot of regeneration going on underneath it. There was, through the 1 billion trees, there was a whole scheme around farmers being able to retire their land and allow natural regeneration as a part of a funding scheme, and managing that in the 1 billion trees program for carbon or whatever. So those opportunities were there for the farmers that wanted to allow regeneration to happen on their paddocks, on their land that was not really suitable for farming, I suppose. So a lot of it, I think it's probably like your central sort of Wanganui bridge to nowhere, and where they try to force farming, and it didn't work, and it's been allowed to return. So yeah, how long you allow it for, that's or how far back you take it. I mean, the previous plan was 1998, I think it was, for your district.
Right.
I don't know if you don't know if you say, well, if it's been there for 25 years, you leave it alone and go to the 2010 plan or something. So yeah, it's I'm not a farmer, so I don't know how much they leave their site to regenerate or not.
Thank you, Mr. Lecoq. I didn't have any further questions.
Thank you. Commissioner McMahon.
Thank you, sir. Good morning, Mr.
Good morning.
I won't keep you long. It's been a long morning, and you are somewhat the meat and the sandwich between the lawyer and the planner. Mr. Clock, just two questions from me, and they are around the topic of risk. In your paragraph 16, in your evidence in chief, you make a statement about acknowledging that the scheduling of SNAs reflects current knowledge, but there's a risk that some Indigenous vegetation may not be included in the identified SNA because it's been largely conducted as a desktop exercise, albeit that sometimes there has been some ground truthing. I just want to get a feel for what that relative degree of risk is about an identified SNA not being fully inclusive of the resource on the ground. I mean, are there any margins that you can speak to in that sense? Are we talking sort of plus or minus 10%, or is it not that simple?
It's probably not that simple. I was not referring to the definition of the boundaries of the SNA. I was referring to new sites. So I had proposed to use an example from outside the district, which the lawyer said I shouldn't. But I'm just thinking, I'm just thinking of there was a threatened plant. It's a tree daisy, Alaria gardneri. We know of about 100 around the Taihape area. There were 4 or 5 around Wairarapa. The QE2 rep chatting to a farmer one day, and they mentioned this plant, and he had it growing, and there was this valley with about 300-400 plants. So it changed the threat status, but we didn't know it was there, and there was no way we were going to be surveying it. So my point is that these discoveries do happen, and the current exercise is not going to pick them up, and I think it recognizes that.
Okay.
So that was where I was coming from with that.
Yes, I must admit I read your paragraph 16 differently, because it was under the heading of SNAs as opposed to your next heading, which is ecosystems and biodiversity outside of SNAs. So I thought you were referring to those SNAs had been identified, but where the boundary might be in the wrong place. But you're saying that wasn't your point in paragraph 16?
No, my point was around the identification of SNAs, where a site like it would have been an SNA, but wasn't. Yeah. Okay.
I'll move on to the second point, and that's your paragraphs 20 and 21. So these are the areas that haven't been identified as SNAs, and and where there's Indigenous features. So that if you like, my understanding of the approach that the council have undertaken is that they've tried to identify SNAs through a desktop process.
Right.
That's their first cab off the rank, if you like. Second cab off the rank is a catch-all that any Indigenous vegetation within the coastal environment is subject to rules.
That's right. That was in place of the SNA, which covered 96 property holders or something.
Yes, yes.
So yeah.
So there'll be SNAs within the coastal environment, but there'll also be Indigenous vegetation within the coastal environment that's not an SNA. And so that latter will be captured by rules on the plan.
That's right.
And
yes.
then the third cap off the rank is Indigenous vegetation that sits outside of the coastal environment, not identified as an SNA, and sits somewhere between the landward boundary of the coastal environment and the eastern boundary of the district. And I think the term ring plane was used earlier. I don't know whether that's an apt term for discussing that area.
I think it's generally known as the ring plane.
Okay. Yes. So my question is, and you would have heard my questions to Ms. Newell, is trying to how we get a feel for the risk of Indigenous vegetation that's significant falling within that area, given that I presume that there are some SNAs being identified within that area, but the Director General's concern is that there are no direct rules on vegetation clearance within that third area that I've referred to.
Yes. So the policy referred to the linkages, the corridors. So those areas that make the district function, that link from the coast to the forests, to the inland areas, they're not magnificent on their own. They probably wouldn't qualify as an SNA on their own, but they contribute to the functioning of the New Plymouth district. They link the coast to the forest for your birds and all the rest of it. So they maintain your rivers. Yeah.
Yes, sorry, I didn't mean to interrupt. Because they're outside the coastal environment, does that lessen their importance as Indigenous vegetation?
No, it doesn't. No.
Okay.
No, it's a different habitat, different vegetation. Yes.
Yeah. And that's it's different, but no less important, no greater importance. It's just different.
it's different. It's fulfilling a different function. Yeah.
Yes. Okay. So the final question in relation to that, and it's one that we'll ask the planner to comment on, is the response or the relief requested by the Director General was that a new rule be put in place that triggers the need for a resource consent where, except for certain circumstances are listed, the extent of removal was greater than 250 square metres of IV. And that's my broad understanding of what the rule is. I'm standing to be corrected on that if I've got it wrong. But I just wondered what the derivation of the 250 is. Is there an ecological basis for nominating that metric?
Not an ecological one. It's pragmatic, I suppose, is the way to look at it. It's trying to find a balance, and I think Ms. Jozen will refer to the policies in neighbouring districts.
Okay.
So just trying to get some consistency.
You can't point us to an ecological reason, though. There might be some good planning reasons, but
no, I can't point to an ecological reason. I mean, in some instances, a single tree is critical. You know,
sure.
So
Yes.
it's ideally you won't have any clearance, but it's trying to find a balance.
Sure, and that's useful. Thank you for your answers.
Thank you.
Mr. Lecoq, I don't have any further questions. I'd like to thank you very much for your assistance as an experienced expert in this field, and enjoy that beautiful Tawa biodiversity. It's an area I know well. I know there's some lovely areas around where you live. So thank you very much.
Thank you. Thank you very much.
We will take a break. I think we don't have a clock in the room, so shall we return at 10:05? Sorry, 11:05. Just have a break and we'll come back and talk to you then, Ms. Jozen. Thank you.
Thank you.
Nice to see some people on time. It's normally the panel is late.
We're sitting here alone, if you can't see.
Oh.
Not quite alone. We've got a couple of Ms. Marco's here very attentively. Ms. Jozen.
Morning. So I'll just do a summary of my evidence. So the key aspects of my evidence relates to biodiversity offsetting, and that further drafting amendments need to be made to better align with the guidance on biodiversity offsetting, particularly with regard to when it's appropriate to use offsetting or biodiversity compensation. And the concern I raised was around the drafting seems to imply that they're interchangeable. I do note the questions you had for Ms. Newell before, so I'm assuming I will get some on them later. The identification of significant Indigenous vegetation and habitat of significant fauna, and my concerns around future-proofing the plan. And again, there's been quite a few questions around that already, so I anticipate there'll be some for me also. The biodiversity maintenance provisions, which I propose, so that's the panels kind of use different terms, but I refer to it as a generic vegetation clearance rule. So that's for those areas not identified as a significant natural area or within the coastal environment. And this new rule is around biodiversity maintenance under section 31(1)(b)(3) of the RMA and the council's responsibility to maintain Indigenous biodiversity. I also cover briefly the rules around forestry activities authorised under the Forestry Act, and I was listening to your discussion with Mr. Lecoq around that, so I'm not quite sure if you have many questions for me, because that is definitely more his area of expertise, and he provided some pretty good examples around how that kind of works in practice. And lastly, consistency with the New Zealand Coastal Policy Statement, particularly the mitigation hierarchy and avoid policies relating to Indigenous biodiversity. Also, more generally through my evidence, I've kind of talked about a gap with regards to the reference to habitats as well as vegetation. So I kind of feel there's a gap with habitats. Vegetation is covered by a lot of the policies and rules, but habitats not so clearly. And I've sought changes to include the reference to habitats in policies and rules. So it's a bit of a quick summary, but I welcome any questions from the panel.
Thank you. And your evidence has been certainly well prepared just to provide that good summary. We've read your evidence and it's quite clear to me, but I'm sure there are some questions. You've been pre-prepared, as you said. So Commissioner Littlejohn, over to you.
Good. Thank you. Good morning, Ms. Yosen. I would echo the Chair's comment there. It was very good to go through. I really wanted to just dig in, if I can, straight to your recommended provisions. And two of them in particular I just wanted to talk about. So in your appendix, where are we? Your appendix 2 proposed text changes. I guess the first one I wanted to ask you about is your recommended change to the definition of significant natural area to mean all Indigenous vegetation which meets the criteria or identified as an area on the maps. And I just wanted to get a sense of what the implication of that change has to the rest of the provisions that we've got, because you've only included the ones you wanted to change, not the ones that you didn't. So have you given some thought to how that addition to the definition would have implications for what are presently just references to significant natural areas that might not have contemplated them being extended to include areas that meet the policy?
So this is just, sorry, just to clarify, so it's around how the rules will apply with that change of definition.
And the policies. I mean, because the defined term operates throughout the entire chapter, and indeed probably in some other chapters as well.
Mm. Yeah, so I guess, I mean, first of all, one of the policies I was, the DG would have requested that it was retained, and I think that was accepted, what must have been accepted by the council officer, and it was identify and map areas of significant Indigenous vegetation and habitat to identify the significant areas, and it listed the criteria. So in my reading, that was kind of opening it to not just being stuff that is mapped, and there's been quite, I'll get to the more clear answer in a second. There has been a lot of discussion around how the mapping can have gaps and does have gaps. So in terms of
well, I think the best way to put it is the mapping might have gaps, not that it does, but that it might. Sorry to interrupt.
Yeah. No, that's okay. So I guess that the main rule would be Indigenous vegetation disturbance within a scheduled natural area. That's sorry. So Eco Rule 1.
Yep.
Gather my thoughts. Eco Rule 1 is probably more relevant. And,
but I mean, Eco Rule 1 to some extent, and I guess this is part of the same question. You see, we've got this phrase scheduled significant natural area. Mm-hmm. Now that's not specifically defined, and I think even the council are suggesting that you still keep the scheduled significant natural area. So yeah. See, for example, here, what I'm looking at is you're suggesting an alteration to significant natural area definition that extends it beyond just being scheduled to others that meet the policy. So do we end up, I guess, getting in a bit of a loop when we then use a phrase scheduled significant natural area? Or do we read that as saying it's a significant natural area, but it confines the defined term to only those ones that are scheduled? Is that how you're intending it would work?
I'm not quite sure if so I don't know if I'm going to be repeating what you just said. So in my view, that there's a difference. So you got the definition for significant natural area, and in my view, that should include a significant natural area is significant regardless of whether it's
I get
scheduled
that.
or not.
Yep.
But the rules break it up into scheduled, and actually noting some of the redrafted, like Eco Rule 5 is just SNA. So potentially I can see how there may be some confusion with the way some of those rules are drafting, because I would have treated Rule 1 as it only applies to those in the schedule.
Okay.
Whereas Eco Rule 5 doesn't have that schedule before significant natural area.
And
so
I mean, it's Eco Rule 5, I guess, which is one of the examples you've got here, because that is a rule that says if you're going to subdivide land that's got a significant natural area, then you need to do all of these things. If we extend the defined term to include scheduled plus others that meet the policy, then it sort of really does change the nature of the rule. And I guess the question is, have you given thought to those sort of follow-on or consequential changes to the structure of the rules that would happen with such a change to the definition?
Yeah, so I think looking at it now and given your question, that there's that inconsistency between whether it's scheduled in the rule, and the way I've drafted the rule the way I've drafted my proposed new rule for the generic clearance and any amendments or accepting what was written for the rules in Appendix 1 to the officer's report was treating it as there are rules to cover the scheduled significant areas, but there's not rules covering the ones that could be significant but haven't been scheduled yet. So I think the way around that is, for example, Eco Rule 5 to be around scheduled natural area.
Okay.
And just that clarification. And I think that will remove that concern with the change to the definition. So, because, the intent that I'm going for is that something is significant because of its values. It doesn't need to be scheduled in the plan, but a schedule is a way to help plan users to identify those things. And I can see how having rules that apply to those that are identified is certainly helpful to a plan user. And then in the instances when stuff may be significant as well.
All right. Well, that sort of leads me into the question about your general rule. You haven't proposed like a bolded title to it, and I'm wondering whether that was just an oversight. I mean, presumably it would have a little chapeau title to it, and presumably based on our discussion, it would be Indigenous vegetation disturbance within a significant natural area not otherwise provided for. Is that how you'd sort of phrase it? Or?
No, I would have had it Indigenous vegetation clearance not applicable to the other rules.
Well,
so it's outside of scheduled areas.
Yeah, but I mean, for example, you have already created a definition of significant natural area, which includes both scheduled and unscheduled. So, well, it's probably one of those things where I would much appreciate it before the close of this hearing. You could potentially go back and do us a version 2 of your Appendix 2, which actually considers those sorts of flow down issues as a consequence of the definition change. And probably, or I'd also appreciate it if you would include your thoughts for what the rule title would be for your new rule, so that we can get a sense of how the whole thing would pull together. rather than potentially create confusion. That would be of some assistance to me. The other thing I wanted to talk to you is more about a general matter, and it's specific to this topic, but it's at a sort of broader level and comes into this discussion around offsetting and compensation. And there's been a suggestion that the policies be amended so that the version 1 concept of no net loss is replaced or got rid of in preference to a version 2 concept of net gain. And I just wanted to know whether you had any particular thoughts on that.
So I'm not quite sure what you mean. So
it's probably because I haven't had a haircut for a long time.
Sorry to cut in, Commissioner Littlejohn.
Yep.
I had almost the same question, but
Yep.
mine's slightly different. And my question was, the department has been perhaps critical of the use of the emission of no net loss, but I was wondering, what's your view in regard specifically to net gain, using the definition of net gain?
Well, I could perhaps provide an absolute focus. If you turn to the definition of biodiversity offset as you've amended, Ms. Josen, right at the end of your Schedule 2, you have inserted back the no net loss and preferably a net gain, which was, Ms. Macbeth suggested to us that the council, she would prefer just the net gain test. So just focus on that, and you've obviously prefer the previous wording, and just some explanation about why.
Yeah, I mean, you've reinstated it into your Eco P6. So we've got a suggestion from Ms. Macbeth that actually no net loss, we don't want that anymore. We actually want a net gain, but you've reverted it back. Is that simply a methodological amendment, or is it a philosophical one?
So I do discuss this in my evidence, and my concern with getting rid of the no net loss is that is the bare minimum, is that there's not going to be a no net loss. And so if you only have the goal of a net gain, if it's just a goal, my concern was that there was a risk that some losses may occur. So you're kind of creating this baseline that at the very least, there's going to be no net loss. So that's in terms of the drafting, and then where I got that thinking from relates to the guidance, which I recognise as guidance. But in my experience with offsetting, and I'm certainly no expert on how offsetting is applied to particular cases in a technical way. There's certain ecologists that specialise in that, but my understanding from that is looking through that guidance, it's very clear that no net loss is the bottom line. And if you don't have that no net loss, then you're starting to mix into that, and this is probably saying you'll have questions for me later on, that kind of the way the plan's drafted, that interchangeable approach to offsetting and compensation, is that if you don't have this goal of no net loss, then potentially you're stepping straight to compensation as well.
Okay. Well, yeah.
But I mean, the definition comes from that guidance, and in my experience, that guidance is what the people that have a lot more experience in this use to guide how they structure and design biodiversity offsets. And that's one of the core principles of an offset being successful, is that idea of no net loss. So I get that the council wanted to take a more positive approach, but I'm concerned that the drafting to create a more positive approach actually takes away some of the quite necessary steps in creating a successful offset.
All right, well, that's yeah, I understand your answer. It's a tricky one. I mean, yeah, it's such a evolving policy / science area at the moment, isn't it, in environmental science? Okay, no, well, I understand your answer to that. The other one, let me just see if I can find it. Actually, no, you've already answered it in the context of my first question. So that was all I really wanted to talk to you about. Thank you.
Thank you.
Good morning, Ms. Yossen. Just had 3 or 4 questions. The first one's just in regards to the which you referred to as the general vegetation clearance area, and you've recommended 250 square metres over the 5 years, I think, is the time period. And
yeah,
in a similar vein to Mr. Lecoq in terms of the question to him, is this a planning reasons for that particular quantum and time period? And also, if you've got any examples of how this has worked in others. I'm familiar with a number of district plans that have a number of different types of habitats where vegetation clearance over particular periods of time are in the rules, and sometimes there's ecological reasons for that, and sometimes there's planning rules for that, and sometimes there are other reasons for that. So I just wanted to get just an understanding from your perspective in regards to the amount that you've provided.
Yep, so the 250 metres squared level came from the Director General's submission. So in forming my evidence, I did have a look at some other plans, and maybe in hindsight, I should have included this table and given some of the requests you've made of, I know my colleague in the lighting provisions to have a comparison to other plans. So I'm happy to complete what is more of a draft and give that to you. But I did look through, so for example, the Central Hawke's Bay plan, they have 1,000 square metres per calendar year. But there's also some more kind of complicated things around the diameter of trees and ground level and canopy. Hastings District Council is similar. So it's Hawke's Bay and then Hastings. Invercargill, which I know is in the deep south, but it was one that I was involved in, so I'm pretty familiar with that. That was 1,000 metres, 1,000 metres in any 5-year period, where the vegetation, there are some restrictions on setbacks from waterbodies. And then the Stratford District Council they actually have a rule around a lone tree based on kind of diameter, and then there's it appears from my reading of it that they don't even have a permitted clearance outside of kind of necessary maintenance and safety for anything. So they're requesting a significance assessment prior to any clearance, and my reading of Waitomo as well is the same as Stratford. So looking at other councils, there seems to be a variation on the area, and within the area sometimes there's kind of further rule parameters around the diameter and canopy. And well, I get that the diameter and canopy is based on the ecological thing. I'm not quite sure that it's that practical for plan users necessarily to go out and measure diameters of trees and understand, that kind of more technical application of determining if that vegetation can be cleared or not. And, you know, for example, the Hastings one has another one of the parts of the rule is around if there's contiguous cover, and I feel that starts to make the rules a lot more complicated. So I had a look at other plans. I noticed that there are what I call clearance thresholds. Sometimes those clearance thresholds are attached to slightly more, a more complicated way to apply the rule to a general person. And
I just wonder there, Ms. Yosin, I think in the first instance it would be useful to have a table, and through the chair's lead, we could request that.
So I'm happy to finish that off and send that through to you.
Could you, sorry to butt in, could you put one addition in? South Taranaki has recently had a plan review, so just for local context.
Yeah, I haven't got it at my table, but I do have it written down, and it says similar but slightly complicated rules. So I'm guessing from my notes that it's to do with that kind of the canopy diameter, contiguous cover, those kind of things. So I guess that 250 is, I know that both Waitomo and Stratford, from my reading, didn't actually have a threshold, and from my reading, requested that any clearance goes through that significance assessment. And I know in my evidence with the Director General's original submission point, the council officer said that they felt that was pretty onerous to have every bit of vegetation be assessed for significance. And I do agree with that's, you know, quite a big demand. And obviously when I do the Section 32A report for you that I will give to you next week, that will be kind of one of the considerations, that a threshold is a good way to kind of allow activities to occur, but set a trigger of when maybe the council should start having a look. So that threshold isn't based on ecological reason. I'm not saying that it couldn't be with more you know, expertise advice on that matter. I'm not saying that I can necessarily get that to you before Monday.
That's fine. The question was, what was it based on? So you're saying it's not necessarily logical reasons. It's looking at comparative examples around the country and providing some strategy to users. Here's the threshold. And I'm reluctant not to have anything like Stratford. I mean, it might be nice. You'd have excellent protection in that, but I think that might be quite onerous for people within the community. And I think inserting it into a plan now would have a bit of, you know, I don't think that would be very fair. I think the council officer brought that up, that people, you know, wouldn't have been given an opportunity to submit on that. So I thought the 250, so in short, I thought the 250 metre squared area in the submission kind of appropriately was a balance between, you know, requiring assessments for everything and looking at when is a trigger appropriate. Well, thank you for that. My next question was going to be, depending on the answer, in regards to the complicated factors. And one of those that came to mind is each habitat's different. So, and there are different groups of flora, for loss of a better word, that are together, some at the coast and some inland, and there'll be different types of environments. And so had that been a consideration of the 250 square metres, you know, thinking about the impact that a clearance might have in a highly sensitive area like a wetland, as opposed to large tracts of bush where 250 square metres may not necessarily have a same significance of impact.
Yeah, so I originally drafted this rule not to apply within the coastal environment because I thought that the coastal environment vegetation clearance rules were appropriate, but I haven't considered it in the context of the wetland, and I'm thinking.
Notwithstanding, there's some other policies and standards in place already. Anyway.
Yeah, and the NPS for freshwater would also apply there as well, and if I recall, it does have restrictions around vegetation clearance within wetlands. So
they're very specific.
Potentially the redrafting I would need to have a look at that more. So I never drafted this to intend to cover wetlands or margins. So it's probably hindsight on my behalf. So you could add in.
My question was probably is theoretical at this stage, because if your answer had been yes, there are ecological reasons for the 250 square metres, I was going to ask, has habitat range and diversity been one of those considerations? And so I'll still ask the question anyway in the absence of that.
Yeah. Yeah.
And that's very helpful, thank you. Just in terms of those guidelines, I'll get this one out of the way, particularly the guideline on biodiversity offsetting. My question is, does that guideline reflect best practice in New Zealand at the present time?
My understanding it does. So I have been involved in council district hearings prior to these guidelines coming out, either prior or around the time that they came out. So previously, DOC actually drafted alongside other government departments its own guidance, and it was kind of probably more referred to the central government guidance on biodiversity offsetting. And I know that there was quite a lot of kickback from opposition to DOC's position on some ecological matters. This was down in Dunedin, and it was Oceana Gold at the time. So this guidance is more recent. It's been written in conjunction with district and regional councils rather than coming from just central government. And I also know that some of the authors of that guidance are people that I've sat on the other side of a hearing to who've drafted it. So I kind of look at it from that perspective, that it seems acceptable to kind of both sides of an ecological argument in terms of protection versus clearance. So I think it's it's balanced. It's more recent than the central government guidance, and I'm not criticising the central government guidance at all, but I do know that when that new guidance came out, we talked internally with our advisors who do a lot of evidence and were involved in both the central government and the local government, and they were comfortable with that. So my understanding from relevant experts is that they're comfortable with that. I see that kind of both sides of both opposing parties are generally comfortable with that. Yeah, so I think it is best practice because it seems widely accepted on both sides of the fence and between different interest groups as well.
Thank you. I just have two last questions, and they might be yes/no answers. The first one is just in regards to offsetting, and it's where you say offsetting is limited, should be used in limited circumstances. And I was just wanting to clarify that that's in terms of relief you're seeking for that, that's in the Eco P6 amendments that you've made, Policy 6 amendments. That was the specific relief you're looking for in terms of offsetting being used in limited circumstances.
I think that relates to separating out offsetting and compensation, because the guidance is quite clear on how offsetting is used, and that actually what it means by appropriate, is the terminology I used in certain circumstances, is that there are some things you cannot offset for in the idea of like for like. So you might have vegetation that's across certain systems that is very, very, I'm probably not in the position to say this, but potentially almost impossible to replicate elsewhere. So you couldn't do an offset for that. So that's where there's certain circumstances where offsetting can't be used.
Yeah, I think we understand what you're trying to say there. Yeah. The last question is just whether you're aware of any examples of general vegetation clearance in the coastal environment in New Plymouth. So like a lot of the tenor of the submissions, there's a risk. I'd put it in the category, there's a fear of loss. If you don't have the rules, there'll be a loss of Indigenous vegetation. I just wondered whether in terms of that fear or risk, there's actually examples of that occurring that you're aware of.
My rule applied outside of the coastal environment. I was fairly comfortable with
Perhaps I'll rephrase it. Are you aware of any general vegetation clearance in New Plymouth?
Oh, as just in general, regardless of postal.
Yes.
No, I'm not.
Thank you.
Thank you, Commissioner McMahon.
Yeah, good morning, Ms. Yosen. I've been listening to your answers to Commissioner Littlejohn and Commissioner Coffin, and by and large, they have covered off the questions that I had signalled earlier. Just two things for your guidance when you come back to us in terms of the homework that Commissioner Littlejohn set you in relation to the definition, and also in relation to your section 32AA assessment. Just on terms of the definition of SNA, and I'm looking at your appendix 2 and the very last entry, the words in red text, which meet the criteria contained in Echo P1, that's the words, were they specified in the Director General's submission notice?
Just open it up.
We've just lost visuals with you, but I presume you can still hear us.
Oh,
We can still hear you.
I can still hear you. I don't know why the
It's
visuals
okay.
are on. Sorry, so in the Director General's submission.
Just while you're looking at, did you prepare that submission, Ms. Yosen, or not?
I provided advice onto it.
Yes. Okay.
Yeah, so it's not up to me what gets included, but I provide advice on what I think
Yes.
should or could be covered. Yeah. So I'm just going through that submission just to double check. Definition. Oh, that's my first. So I'm not quite sure if it's exactly the same as the, I'm just having a look.
I can help there. On page 13 of the submission table for the director, there is a request to amend the definition, but it makes a reference to meets the criteria outlined in NE.
Yeah, NE policy 1. So I'd say, I don't think NE policy 1 has a criteria, does it?
No, there is no such thing as NE policy 1.
Yeah,
That's
so
one
I'm
of the
assuming.
strategic.
Yeah, I've just, yeah, I mean, I haven't checked, but I'm pretty sure it doesn't have a criteria in policy 1. So I'm assuming that was an error, and it does actually mean the eco policy 1. Because that is where the criteria is given.
Sure. Look, putting aside any legalities there, Neil might want to comment on that, but I thought Commissioner Littlejohn raised a very important point about the meaning of words and the definitions and whether they have unintended consequences. So the definition in the notified version was predicated on a clear distinction between SNA being used in rules, and I think it's only used in rule 1, and Indigenous vegetation being used in the remainder. So the addition of those words may change that sort of determination. So when you're coming back to us, you might, if you're still of a mind to run with that alteration to the designation, then I think you're going to have to make consequential changes to the rules that differentiate between scheduled and non-scheduled SNAs. Yeah. So there's not a question there, just an observation to assist you in that task.
Yeah, and I think that's when I talked about Rule 5, is that Rule 5 didn't really have that reference to scheduled, whereas Rule 1 did. So, so I think, yeah, consistency throughout the rules
I guess
certainly something I'll look at.
Sure. I guess implicit in that invitation to you is an invitation to also to consider whether you still think there's a need to change the definition, or whether we can rely on the rules in R1 to R6 or whatever they are in their plain reading. In terms of the second issue, the section 32AA, look, I don't want to make a big issue of this, but it was my expectation that would have been included in your evidence, and the instructions and the hearings procedures indicated that. So that they weren't, but going forward, if you're attending again, that is our expectation. because it's part and parcel. You're getting a second opportunity to provide it. And so I'm happy to provide that. But in doing that, I think I'm really keen to understand how you've tackled the concept of risk of acting and not acting, spatially, in terms of spatial terms. And, you know, we've asked Ms. Macbeth to provide us with a diagram or plan that shows the spatial extent of the coastal area. And by doing that, it'll define that part of the district that's not subject to the SNA or coastal area rules. So that'll help define the area that is at risk, but it won't in itself tell us what that risk is. So that's why I was asking Mr. Lecoq some of those questions about his paragraph 23. And you know, he answered to the best that he could, but I'm still not sure that I understand what the risk is and how that equates for the need for intervention. And I certainly don't understand the costs and benefits of that intervention. So there's a bit of work there. I guess that's what I'm saying. Thank you, sir.
Thank you. Ms. Josen, after all those questions, I only have one. It's circling back to this hierarchy that you've presumed or proposed, whether that's based actually on the reading of the Act, or is that coming out of the guidance? The
biodiversity offsetting.
Yes.
Yeah. So yeah, I do know that the Act does appear to use them interchangeably, but where I think that in the application of biodiversity offsetting and compensation, the experts who make those decisions refer to the guidance to guide them on how to make those decisions, and that guidance does have that very clear hierarchy. And I think it's similar to when the relevance of the guidance and why that hierarchy comes into play is probably similar to when ecologists, there's lots of resources and tools available to help them give advice on what is significant or not. So I see it, that connection there is that when an offset or biodiversity is proposed, you would get someone who is an expert to do that. So proposed under the Act, you'd get an expert to do that, and they would look to that guidance because that is what is best practice in that industry. So while it's not written in the Act, there certainly is a hierarchy when it comes to the practical application of creating an offset or proposing compensation.
All right. Look, I think that's clear, and I certainly appreciated your answers to Commissioner Coffin about whether you saw that as a plan as being best practice. I think I've been involved in this topic for over 10 years with some major cases, and all of those authors are very familiar to me, as are many of the people involved in this this hearing. So I've tracked through all the issues and the reason why I think that the guidance is important, and the fact that you're telling us that you, as someone working in this space, you see that as best practice, I think is quite important. So thank you for that evidence. Look, that's all we have. Just wanted to summarise the actions. Do you have a list there, Ms. Newell, that you could read back to us about what you think you're doing, or just confirm what you're doing?
Sorry, was that directed at me?
Yes. Or,
So yes, I've been trying to make a list. My list is I am to provide you with any updates on case law on offsetting and compensation that might relate to decisions after the amendments to the Act that dealt with that. Ms. Josen is to do a Section 32AA analysis.
Yes.
Ms. Yosen is going to provide a table of comparable plan provisions about the threshold trigger for Indigenous vegetation clearance to be considered as a consented activity. Ms. Yosen is to reconsider the definition that she's proposed of SNAs and to consider the circularity that might have introduced in the plan. And that's in her appendix 2, and she's to consider a title for the new rule that she's proposed. And I think that covers it.
That's my recollection too. I'll look around the table. And look, I do want to sort of agree or negotiate some timeframes on those because there's a bit of work to do there. And perhaps looking at Ms. Macbeth, I think the 32AA report analysis is probably the most important for us in terms of just getting a handle on that, what you're proposing before the verbal right of reply. The other matters probably aren't as important, but Ms. Macbeth, what's your view?
It would be very useful to have a couple of days to look at the 32AA.
Yes, so I think you're probably reporting back to us Tuesday afternoon. Yes, so what are we? We're Wednesday now. Yeah, and you did indicate that was possible by perhaps Monday morning. Is that possible to have to us?
I have other evidence due for king salmon on Friday, so that is and I usually don't actually work on Thursdays, so I may have to find alternative childcare for that reason. But yeah, I definitely not before Monday. I wouldn't. I've still got a complete evidence, and it will probably be a weekend job for me.
Yes. All right. Look, the other thing we should talk to you about, and we haven't had a chance to confer with Commissioner Littlejohn about this, but because he's in Auckland, and just signalling that we're sensing that it might be quite useful for the officers' formal written right of reply to do some conferencing between the key planners about these rules. It's in an expert conferencing sense, because there's some proposals put up, which obviously on their face have a basis, have some merit. I'm always a great fan of, particularly around these more complex issues, and this is a complex area of planning practice. So we're thinking that might be helpful, and there was a 2-week period, I think, from the end of the hearing to when we'd actually get the written right of reply. So perhaps if you could give an indication about being involved in that, we can of course direct that, but I always like to see whether people see value in that process. Yeah,
absolutely. My only commitments are the king salmon hearing, and I think it starts on the 18th, and there's a lot of witnesses for king salmon, so we might appear on the 20th or the 21st up in Blenheim. So that's kind of my only unmovable commitment around attending conferencing.
Yeah, well, there's a range of planners involved in this topic. So look, we're floating that out there. Ms. Macbeth, if you can come back to us, maybe have a think about that, and we need you to coordinate that. But I do know that the planners, when we're down with all the evidence in front of us, really thinking about and talking about that as practitioners, that can add quite a lot of value to the panel, and particularly where it's run in the classic way of where there's agreement, that's specified, where there's disagreement, there's reasons why there's disagreement. It does add an extra process, but I feel that personally would add value, and the panel would probably appreciate that. Okay, well, it sounds like that's something we can work on and think about, and we'll just confirm that in the next, or probably Yeah, well, we should probably wait for the other witnesses. So we'll confirm that at the end of the hearing, just to see whether that's actually going to happen and what the timeframes might be. Thank you. Thank you very much for your assistance.
Thank you.
Thank you very much, Commissioners. So that's the end of the case for the Department of Conservation. I'd just like to add that I endorse your idea of having the planners conferencing as well, so enthusiastic about that. And we will provide the rest of that information as soon as we can.
And just the timing on the other material, I think that could be sort of targeted for the end of next week, would be a reasonable time frame. So outside of the section 32 AA, there's some other tasks, if that was acceptable.
Yeah, that sounds acceptable. So we'll aim for the section 32 AA on Monday. Can we say by midday?
Yeah, well, I think that's fair. Yeah. And we'll obviously, particularly we do conferencing and there's a written right of reply as well. Ms. Macbeth will be able to give us some initial thoughts on that, and then we can circle back, or she can circle back once that's in. So thank you very much.
Can I raise something before we go?
Yes.
I'm just going to ask if Ms. Newell or Ms. Yosen are going to stay online to hear Forest and Birds presentation. And that's not planning. You were planning to? Okay. Yes. Just given that the department is doing much of the heavy lifting here in terms of the planning work, I don't know if you've had a chance to see Mr. Jennings' submissions, but he, Forest and Bird, as far as I can tell, rely effectively very much on your evidence, Ms. Yosen, in terms of amendments to the plan. But they also, in paragraph 7, have a list of 4 items where they say you don't go far enough, or other things ought to be considered. And one of the things I'm just concerned about is that you have considered those matters, because Forest and Bird have not called a planning witness, and so we can't demand a section 32 AA from Mr. Jennings because he's a lawyer, and that 32 AAs are too hard for lawyers. That's why they leave it for planners to do. So it does mean that we'd be in a position of having some further changes suggested by Forest and Bird that hadn't gone through that level of analysis. Now, it may be that I'm going to suggest to Mr. Jennings that Forest and Bird get down on bended knee and ask politely to have your intellectual rigour brought to this, and potentially even a compiled set of provisions that might represent the preferred provisions by Forest and Bird and the department. Now, I appreciate that there may be situations where you differ, but they could, I think, be easily identified by way of footnote or highlighting. And again, I haven't discussed this with the rest of the panel, but it just did occur to me that given that both of Forest and Bird and the department are very closely aligned in terms of seeking quite significant changes to the structure of the eco chapter, we would be benefited, I think, by having a compiled set of requests with a detailed analysis done of those for our deliberation.
We'd be happy with that proposal. Of course, it will totally depend on what Mr. Jennings has to say as well, but we'll be talking to him anyway. So
all right. Well, I appreciate that. And look, I cannot force you to talk to Mr. Jennings, but it would be of assistance to us ultimately if there was a degree of what's the word, cooperation between the two of you in terms of the changes you're seeking. That would be assisted.
Yeah. So you just wanted me to consider what Mr. Jennings has written in his paragraph 7 as part of my section 32A.
Well, only if he asks you to nicely.
I think that may well occur, but we'll wait to see what he says.
Yes.
Thank you very much.
Look, just before we sign off on that, I am a trifle concerned that Ms. Yosen's in the position of representing or being seen to represent Forest and Bird as well. But and you're not in, even though you've carefully paraphrased your evidence that this is expert from you and code of conduct matters, just have a little concern that you may be, to put it, forced into representing a position or commenting on a position that perhaps you don't hold. So as long as your 32AA report comes to us as your professional opinion, not representing any particular view, or as a planner, there's a bit of a fine line there. So whether you want to comment on that, Ms. Newell or Ms. Yosen.
Thank you for raising it as something that we are always very conscious of when calling experts. And in this case, there are some differences between Forest and Birds position and the Director General's position, and Ms. Yosen is very aware of her obligations as an expert, so she'll bear that in mind. And it might be that she has to specify when any difficulty of that nature has arisen in regards to anything that we might consider in relation to Forest and Birds position. So probably will note that specifically actually in whatever response comes back.
Thank you. I just wouldn't like Ms. Yosen to be compromised by the request. That's all. And just were you aware that Forest and Bird were adopting, or things like partially adopting or cherry picking some of the provisions?
We were aware of their approach to this hearing in that it was only going to be Mr. Jennings presenting legal submissions, but we, as far as I'm aware, we hadn't shared drafts of evidence.
But were you aware?
No, I hadn't shared drafts of evidence prior to submitting them.
I haven't read the legal submission either, so I'm curious to know what's in paragraph 7.
Yeah, that's all right. I just wanted to check that, they have adopted your evidence or part of it, whether you're aware of that before Mr. Jennings released his submissions.
No, we weren't. We only, I can only assume that he got the evidence from the website.
Yes, which he's quite entitled to do. So, I just wanted to double check the process. All right, thank you for that. And we'll now move to Mr. Jennings. I do need to signal that we are behind, obviously. In terms of Mr. O'Carroll, we are going to take a break for lunch after the Forest and Bird submission. So, and we'll have to have you straight after lunch. So is that okay? Yes, so thank you very much. Right, we're getting some stretching exercises done here by some of the panel. These chairs aren't...
We're not rugby players anymore.
Yeah, and that great. So we are now turning to you, Mr. Jennings, if you're there.
The commissioners, yes, I'm here.
Yes, thank you. Right, the floor is yours.
Okay, thank you. Well, first of all, I just want to acknowledge the work that the council's put into identifying SNAs, and it appears to be a tremendous amount of work, and congratulate the council for undertaking that process. But in saying that, Forest and Bird would also like to say that it has significant issues with the proposed plan moving forward. Its concerns relate to, obviously, the protection of significant Indigenous biodiversity and the maintenance of Indigenous biodiversity. And the reasons for those is that because in Forest and Bird's opinion, it doesn't believe that the proposed plan goes far enough in protecting the identified SNAs that it has identified, because it excludes covenanted SNAs. It doesn't give effect to the NZCPS policy 11 to the full effect, and it doesn't provide a mechanism for identifying and protecting further unmapped or unidentified SNAs, and it doesn't provide a regulatory mechanism for maintaining Indigenous biodiversity. Forest and Bird says the council relies on basically community attitude, the goodwill of the public, and other legal protection mechanisms that don't necessarily represent the purpose of the RMA. And also Forest and Bird understands that the proposed plan relies on other particular zone rules that may require the effects on Indigenous biodiversity to be considered in those particular zone rules. So that's my real basic summary of my submissions there, commissioners, and I thought I'd just save it mostly for questions.
Yes, and thank you. We have read your submissions. And I will go straight to Commissioner Littlejohn to see whether he has any questions.
All right, thank you. Thank you, Mr. Jennings. That was very helpful for your submissions. I wanted just to talk, there's only a couple of matters I wanted to talk to you about, really. Your paragraph 7A,
Yes.
this is, and I mean, the structure of your submissions is helpful, although it would have been more helpful if you'd called a planner. I'll say that, and said planner had done a 32AA, and I fear that I might have embarrassed Ms. Yosin by suggesting that she consider your relief, but I've been told off for that, and I stand duly. It's one of the difficulties of having hearings where we don't chat over morning tea. So there we go. And you've got your list of things that you wanted. 7, you say you support the relief in terms of policies 4 and 6 and the new permitted and RD rules for general clearance. And then you've got 4 items there. The first one is amending the definition of SNA to include areas that meet the policy. Now, I'm not sure if you read right to the end of Appendix 2 of Ms. Yosin's evidence, but she has suggested such a thing. Had you picked that up?
I think you're right, Mr. Littlejohn, is that I didn't go all the way to the very, very bottom of her evidence, and I think I missed that. Yeah.
So to some extent, you'd also support her suggestion around changing the definition to incorporate within that defined term any area of vegetation that meets the Eco P1 criteria.
Yes,
Okay.
Forest and Bird would, and I did hear one of the other commissioners' questions to Doc as to whether they covered that in their submission, and that particular submission point is covered in Forest and Bird's submission.
Yeah, I see that. Okay. All right, so that's helpful. Then your other items there are around compensation versus offsetting, which I think we've got a lot of evidence on. That's good. And then some specific mechanics around the new rules that are proposed there, which I'm sure we can think about there. So that's helpful. Just want to now, I guess, go out a little bit to a higher level and sort of come back to where you say in paragraph 15, you talk about the district council decision, which I read with interest in preparation for this case. And you rely on this, as does the council, to support, I guess, it sounds funny to call it this, but it's a palette-based approach, i.e. regulatory and non-regulatory methods to achieve an objective. And you're critical of the council not identifying as SNA and mapping those areas which are protected by existing QE2 covenants or have a reserve status, for example. And as I read your reliance on the Environment Court's decision, and I'm looking here in particular at the 4th bullet point. I've got to push back and say I didn't read the decision as saying that it wasn't possible to provide for protection by relying on the existence of other conservation mechanisms. But the criticism the court was making was that in the case of the operative district plan, that was the only method it was effectively relying on. And so the phrasing reliance primarily on covenants does not provide the protection. Now, the world's changed significantly since then. And not only do you have reliance on covenants, but you've now got the SNA schedule with 300 some additional sites on it. So do you think it's right to still criticise the council's use of those conservation mechanisms as meeting in part its obligations under Section 6C?
I still think they should be mapped, or Forest and Bird thinks they should still be mapped. And I think the council is right in offering rates relief to property owners that do get those covenanted. That's an excellent non-regulatory mechanism to get more protection on these types of lands. And I'd also say in the decision, it seems that was about, I think there, from memory, there were 2 sets of schedules in the proposed plan. One had legal protection, others didn't. The ones that didn't were included in the plan for protection. And then I think, from my understanding, the court went on to make a declaration that the omission of the council to not include in the district plan those unprotected lands was a contravened its duty, or was a failure to give effect to the regional policies. And I think that's in paragraph 114.
It says the omission of the council to include in Appendix 21.2 SNAs which have been identified applying the criteria in Appendix 21.1 contravenes its duty to protect and fails to give effect to. So your submission is that it's sort of game over for this approach by the council, and that they effectively have to include those sites in their new schedule in order to avoid falling into the same mistake they did last time. Is that your legal argument?
That's Forest and Bird's legal argument, yes.
So I'm just making a note, relies on. Okay, that's helpful, thank you. Okay, one of the, and I guess it's a minor point because it's sort of overshadowed by that last quite compelling legal argument, if I can put it like that, is you had a criticism at paragraph 31 of your submissions that the QE2 submission stated that there are covenanted areas that do not protect Indigenous vegetation, and you were saying that this was a reason why they should be included. I do note that the definition put forward for conservation covenant makes it quite clear that if it is an area that is a QE2 covenant, that it be directed at protecting Indigenous biodiversity. So, I mean, on the basis of that, assuming we went down the council's path, would you be confident that that definition would only ensure those QE2 covenants that protect Indigenous biodiversity are excluded from the rule, but those that don't wouldn't be?
Oh, I'd have to really think about that, Mr. Littlejohn. I haven't given that much thought, and I don't have the definition in front of me to give it a lot of thought. Sorry about that.
Okay.
But yeah, I'm not quite sure how the rule and that definition function or interact.
Yeah. Okay. Well, that's something we can think about if we get to that position. The only other point I wanted to really talk to you about was your request for the significance criteria to be expanded, and whether you've got, I mean, you've heard the evidence. We've got evidence from Mr. Shaw. We've also got evidence from an ecologist, from Mr. Lecoq, who, for the most part, as I understood his answers to questions today, supports Mr. Shaw's approach. Mr. Shaw says that the approach as between what Forest and Bird are suggesting in terms of the statement of the criteria and what is in the plan are very similar, and he says he doesn't think you need to go much further than that. you are still, or Forest and Bird still contending for a more fulsome Eco P1 policy, isn't it?
Yes, yes.
Okay.
And I think Mr. Shaw also addresses, like, I'm pretty sure I say in paragraph 22, he refers to the NPSIB, and it would be advisable, in his opinion, to adopt the 4 headings used in there.
Yep. Okay. Now, you're not calling any of your own ecological evidence to support this relief change?
Not at this stage, no.
So are you intending to do it at some stage during these hearings?
No, not during the council hearings, and I couldn't really say when we would be.
Okay. Sort of sounds like you're sort of biding your time until round 2, which I'm a little bit concerned to hear you imply. In the absence of any evidence, is there any relevant case law that would support a fuller recitation of these criteria for Forest and Bird?
Off the top of my head, I can't think of any. All I can think of are cases where these criteria were already included in the plan. And then a judicial comment was made on the contents of it, I believe. And I think one of the cases may have been the Otago Regional Policy Statement, where they specifically addressed compensation and offsetting, I believe, there.
Okay. Thank you, Mr. Jennings. I didn't have anything further. Thank you, Mr. Chair.
Thank you,
Commissioner Coffin. Good morning, Mr. Jennings. I don't think we've met before, so nice to meet you.
Pleasure to meet you.
I have a few questions, and I'm just going to use your legal submissions, and I'm actually going to start from the back and move forward, because they kind of make sense when in that order. So I'm just looking at paragraph 38, and it's just you're discussing the Department of Conservation limit of the 250 square metres, and this is over a 5-year period, vis-a-vis the Forest and Bird submission for 100 square metres, I think over the 5-year period from memory.
Yes, that's correct, Commissioner.
I was just wondering if you're able to provide any particular reasons for the 100 metres over the 5 years.
For the 100 metres, I can't provide any comment other than what was stated in the Forest and Bird submission for the 100 metres. And in terms of whether it's ecological or pragmatic, I can't really comment.
Thank you. Just at paragraph 38, as we say, Forest and Bird submit the council is wholly relying on a community attitude and inadequate zone rules. And I just wondered what Forest and Bird's view was of bringing the community along with them. We've heard a number of submissions from landowners this week, which were, including federated farmers, which, although we've had a few grumpy people come along, overall we had heard from landowners who were supportive of the process that the council's gone through, to not only in terms of the district plan, but encouraging and advocating for a number of measures on property which would go to conserving Indigenous biodiversity. And I just wondered whether it seems that Forest and Bird submissions are quite strongly focused on the stick and almost dismissive, in my view, of bringing the community along. And it seems that to me that bringing the community along with you is actually an essential part, because you may have rules in the plan, but people can choose whether they actually want to comply with them. So I just wondered whether you had a view that in that regard.
I think Forest and Bird thinks it's an excellent idea to bring the community along, no doubt. But I think from memory, in the Forest and Bird case, I think the judge actually commented on some of those concerns that a lot of the community would have, in terms of there being that community goodwill that nobody wants to cut down anymore, Indigenous vegetation. And I think the judge said in there, and I can't remember the specific paragraph anymore, he said, well, those people shouldn't really have an issue with rules being implemented over those areas. those sorts of, and I can't remember some of the other judicial comments that he made in regards to that, but I think we've tried to, we're at a stage with Indigenous biodiversity loss. We need to step up the game to ensure that we don't lose any more. And we've gone down the community route and relied on goodwill. They're definitely coming along, and it's excellent, and I encourage that totally, but it's also required in Forest and Bird's opinion to have a regulatory mechanism as well.
Just to, I suppose, and just taking that a little bit further, at paragraph 32, you just say Forest and Bird submits control of Indigenous vegetation disturbance is very limited outside of SNAs and the coastal environment. And a question that I'd put to the Department of Conservation Planner was a question around whether they were aware of general clearance of Indigenous vegetation in New Plymouth, because often people's behaviour in the future is influenced by the people's behaviour in the past. And I just wondered whether you were aware, or the Forest and Bird were aware of general clearance of Indigenous vegetation in New Plymouth.
I'm not aware, but perhaps one of the Forest and Bird members are aware, somewhere up there.
I just had a couple more questions. I think I'll just quickly go through. This is just a question we'd asked the Department of Conservation, and I'll ask yourselves as well, was just around the status or the weight that should be given to the draft National Policy Statement on Indigenous Biodiversity. Obviously, when it's enacted, it'll be very important and set the framework for much of this work. But at the present time, for all intents and purposes, it's drafted sitting there and has been for a while. And whether you had a particular view in regards to its status and the weight that we should give it.
In terms of the weight, it's definitely, it should be considered by the commissioners in terms of how much weight. I understand that perhaps from memory, there is some cases that didn't give it a lot of weight, given its current status as just a proposed draft document. So until we hear more from the government, unfortunately, I don't think we can give it a huge amount of weight, but it definitely should be a consideration.
So in terms of a consideration, are you thinking it would have the type of consideration that other matters that we should be considering? I'm just thinking in an RMA context for us.
Yes, yes, and I was thinking along those lines in terms of other matters that the commissioners could consider.
And just I think this is my last question. It looks like it is. This is a best practice. This is at paragraph 23, where you just submit that amendments better reflect the significance criteria of the draft NPSIB and current best practice. And I was just wondering whether you were referring to something specifically, because you've doubled around to your submission, but I was wondering whether best practice was you had in mind that it was a particular guidance document that you're referring to, or particular examples of that around the country.
Perhaps the submission drafter was referring to either, I understand there's the DOC guidance on biodiversity offsetting, and then I understand there's the international guidance, the BBOP, can't remember what they stand for, and a lot of the language I understand that comes into the offsetting policies that a lot of councils use, where they use significant residual adverse effects, are reflected in those best practice models. I know that the New Plymouth District Council doesn't use significant residual effects, which is great, because it doesn't, when the language is used in these different documents, sometimes if only bits of it are used and not all of it, the full meaning doesn't come across. So I understand that significant in, say, for example, the BBOP includes more than or less, virtually every residual adverse effect that could, whereas in an RMA context, people could say significant residual adverse effects might not be more than minor or less than minor.
I'm unfamiliar with those particular guidelines. Are you aware that have they been adopted by any of the professional bodies in New Zealand or any particular institutions?
I'm not sure that they've, in what sense do you mean? Like, do they refer to it and do they use the same language in their plans? Is that what you mean? Or or
I
the
was just
ecology.
meaning, because I was asking, what was best practice, and that was one of the examples was the BBOP documents, and I just wondered whether they had been adopted by peak organisations in New Zealand as best practice, or whether they were just international guidelines prepared by experts internationally.
Other than I think they are in the New Zealand guidelines. Correct me if I'm wrong, but I think there's the BOP, and then there's the New Zealand guidelines, and then DOC has its guidelines as well that Ms. Yosen and Ms. Newell were referring to, and they all use similar language, but I could be not correct in that aspect.
Well, thank you very much, Mr. Jennings.
Thank you, Mr. Jennings. I have some broader questions. Can you, just about Forest and Bird as an organisation, just to clarify some matters for me. The Forest and Bird, are you an incorporated society, or what's your status?
It's an incorporated society.
And you're representing who?
Forest and Bird, the Royal Forest and Bird Protection Society of New Zealand is the full name of it.
Yes. And is there a Taranaki branch?
Oh, right. Yes. There's, I understand, 32 branches underneath the Forest and Bird umbrella, and they all have their own branches, and I'm not 100% on the interaction, but I am pretty sure that they all come under the National Forest and Bird umbrella.
So tell me about the Taranaki Forest and Bird branches. How many are there? Where are they based? Just for our knowledge.
Sorry, Commissioner, I really don't know.
So back to my question, who are you representing?
Royal Forest and Bird, the national
body. So that's you're not representing the local bodies, the local committees?
Well, I would be, in the sense that they're associated with the National Royal Forest and Bird Protection Society.
Who wrote the submission for Forest and Bird?
Let me look at the name on it. His name's Tom Kay, and that's for the Royal New Zealand for Forest and Bird. I'm not sure if did a Taranaki branch file a submission.
Where does Mr. Kay live?
Wellington.
Was he in communication with the local branches of Forest and Bird and Taranaki when he drafted the submission?
He could have been. I really don't know.
Can you please provide me that answer in writing?
What I just said, or whether?
No. Can you please provide some clarity for the panel about who wrote the submission and the means of consultation with the local branches in Taranaki of Forest and Bird?
Yes, I can ask that. I know Mr. Kay's left Forest and Bird last month or the month before, so I'll try to touch base with him and see if he can provide some guidance.
And you'll report back to the panel with your answer by the hearings administrator?
Yes.
Thank you. I now want to ask questions about funding for Forest and Bird. What is your funding base?
From my understanding, it's mostly gifts and donations, and then a few bequests.
Is there any public funding, any government funding for the work you do?
No.
Okay, thank you. Now I want to move to your statement where paragraph 2, you say you adopt DOC's evidence from Ms. Yosen and Mr. Lecoq. What's your understanding of adopting an expert?
Basically, I understand it's I adopt everything they say virtually as our own evidence,
Including their answers to verbal questions?
Yes.
Including their their analysis and potentially future expert conferencing and advice to the panel via that method? You adopt that as well?
I'm not sure if it goes that far, Commissioner. Without being able to know what they were going to say, I had the benefit of reading Ms. Yorzen's and Mr. Lecoq's evidence online as provided by the council.
So would you amend your paragraph 2 to say that you adopt the evidence as filed rather than evidence? Because I think as a trained lawyer, you understand there's two types of evidence. There's the written evidence and there's also the evidence we receive through questions and answers. Is that correct?
Yes, I think you're right, Commissioner, and perhaps I can amend it to say as filed on, let me look at the date on their submission. As filed on 24 September 2021, I believe, for both Mr. Lecoq and Ms. Yorzen.
Thank you. Then how do you deal with the fact that in paragraph 7, it looks like you only partially dropped the evidence of Ms. Yorzen? How does that work?
By providing that that paragraph there slightly modified into the legal submission.
You're not calling any evidence, are you, that we could rely on?
No, Commissioner.
And as a lawyer, you would understand that when decision makers at whatever level of a process need to make decisions, we can only rely on expert evidence in these matters of expert matters, ecology and planning. That's right, isn't it?
Yes, Your Honor, and legal submissions.
I think Your Honour's going a bit far, but maybe
He is honourable, but I don't know if he's wrong.
He's working on it.
Well, you are sounding like a judge, Stephen.
Yes, yeah, well, no, I think this is quite important to me that we are in a quasi judicial role. We've got certain rules about decision making, and we have to have evidence in these expert areas to help us with our decisions. So, look, I do want to turn to another topic, which is your paragraph 8. Have you read the hearings procedures that were circulated prior to the hearing starting?
I did not read them, no, Commissioner.
So you wouldn't be aware then that when parties are presenting changes to the 42A report, we require a marked up version to be presented to us so we can fully understand exactly what you're seeking in relation to the evolution of the provisions through the hearing?
No, I was not aware of that, Commissioner.
So could I ask that you do that for us? Because all the other parties are doing that, and that we followed up with a separate minute, just confirming that was our expectation, I think minute 3 or minute 4. So could you please provide that to the hearings administrator, perhaps by Monday morning next, because we'll need to have a think about that when the staff are reporting back to us on Tuesday.
Yes, Commissioner.
Thank you. Just one final matter, just for the record, is it Forest and Bird's position that you have decided not to lead any expert evidence at this hearing on the basis that in any subsequent processes on appeal, you would lead evidence to support your case?
Well, if it went to a hearing, or if we did appeal it, if the decision was appealed and it went to a hearing, then in many cases we would call evidence, we would have to call evidence, but there may be other evidence called by other parties, or we may not even appeal. We may just join as a Section 274 party, just depending on what happens, Commissioner.
So what's the position of Forest and Bird? I just want to understand, this is a part of the RMA Schedule 1 process. Is it Forest and Bird's position that you don't need to lead evidence at the first stage hearings? And that somehow we can just rely on legal submissions? Is that your position?
No, Commissioner.
That's not what you said to Commissioner Littlejohn. You said that you weren't leading evidence at this stage of the evidence of the process. So I'm just wanting to understand why you haven't led any evidence. You've got significant changes that you're suggesting which have expert matters associated with them, and where that leaves us with considering your submissions.
Well, Forest and Bird, as you pointed out earlier, is a not-for-profit organization with limited resources and often has to rely on other parties to hopefully bring evidence. And if they don't, then that's the best Forest and Bird can do at this stage. If things progress further, then Forest and Bird would have to procure some money in some way, shape, or form, or find it.
Do you think that limits our ability to make a good decision on the basis that you're asking significant changes without any evidence that we can ask experts about?
I don't think it. I mean, it would be wonderful if Forest and Bird could bring evidence, as much evidence as it would like to in every council hearing, but it just simply cannot do that. But I think the commissioners are very well capable of making an excellent decision on this chapter.
Okay. Thank you very much. Thank you for your assistance. Thank you.
Thank you.
Thank you. We will break for lunch, and at the time, it's 12:30, so 1:15 we'll be back. And thank you for your sitting in and listening to that, and we'll hear from you after lunch. Thank you.
Yeah.
Welcome back, everyone. Trust you all had a good break and some nice lunch. So Mr. O'Carroll, could you come forward to the desk here? So Mr. O'Carroll, I understand there's some evidence from Mr. Dixon who lodged a submission, and you've got your own evidence as well you've tabled. So the way things work here is that basically the floor is yours to talk to us. We're happy for you to present images and photographs or anything on the screen, to talk to those, and quite often those are quite helpful just so we get an idea of the area that you're talking about, and to get from you just your views. So it's over to you, and welcome again.
Kia ora. Kia ora koutou. Ka ngoi ngā mahi ki a koutou. Anei taku ipiha. Karana ki te maunga, ko waka tino, ngā parutu noi ngā awa, au tama ka whenua. Ahi tama te iwi. O parenini te mātua kānoi, ahi tama o wha. Yeah, I'm here today to
Just pull the microphone a little bit forward and sort of we can do it. So yeah, that's good. Thank you.
yeah, I'm here to support Sam Dixon's submission to include the White Cliffs Walkway, the public access corridor. I didn't prepare any pictures or slides or anything, but I can explain where the area is if you're unfamiliar with it. Paraninihi is the also known as the White Cliffs, which is North Taranaki. The area that we're talking about is the White Cliffs Walkway, which follows the ridges along those cliffs to the Tohoro Stock Tunnel. And then to the Tohoro Stock Tunnel is about where the confiscation line is, and going north of that goes to Ongaparutu. Further to my written submission, I just want to point out that that area is the pest management area, which is south of the Tohoro Stock Tunnel. It goes south to the Araware, to the bushes. We've done quite a bit of work in there over probably 10, 12 years, protecting the significant species like kiwi and many other taonga species. We also introduced the kōkaku in there about 2017. That's a bit of walkway from the Waipinga to the Stock Tunnel. That's kind of been taken off the maintenance of the public walkway. That used to be quite a good walkway for our volunteers, and they were quite keen to do that. However, that's kind of fallen off now. The volunteers don't do that line anymore because of the gorse is overgrown down on the north end. You can't even push through there at the moment, and we have a lot of our traps go missing up there on the north end. What was sitting here this morning, what I did find interesting in kōrero was the kōrero about bats. And I was part of that team that did the survey for bats in that area with the About Messenger project. What I'd like to note is that there is bats present in that area, however, in low numbers. The bat expert, and I must know I'm not an ecologist or an expert in bats, but I was part of that team. But the bat expert was quite not surprised, but he noted that he'd never seen bats so close to the coast, which I thought was cool. And another one I sort of like to notice that piece of bush is continuous from the coast. You've got coastal forest continuous into inland forest, and it's the only piece of forest in the west coast of the North Island that it has that continuous bush from coastal to inland. And then we're going to the north of the Stock Tunnel now, and is that the walkway that used to be the walkway from the Stock Tunnel to Ongaparutu. That's all that land was occupied, but basically owned by my tūpuna back in the day, Te Kāia, and then subsequently owned by Taro. And then after that, a deal was struck between the ancestor of the current landowner, and then there's that land now. Well, that area is quite culturally significant. It's got a lot of past sites, Wahitapi sites. Not having access to that walkway prevents us from getting to those culturally significant sites. At the moment, First Gas is doing quite a lot of work up there, and we can't really monitor what they're doing up there because the access is can't get access.
Mm.
And it was also part of when the district council mapped all the cultural significant sites, like past sites in the Ngahi Tamarohe, but we weren't able to get into that area to map those that area, because we couldn't get access. But we did get to most of the other sites. Ngahi Tama. I think I'll just leave it for questions now.
Sure, great.
Yeah.
Just a couple of introductory questions. One is around Mr. Dixon.
Yeah.
So he's not available today. Is that why he's not here? Is that?
I was talking to Sam, and he'd planned a holiday with his kids for the school holidays many months ago, and he couldn't get out of it.
Okay.
I apologise.
Yes, that's good, because we do have his evidence.
Suggesting the children were more important than us.
Or Tautoko, that is, yeah. No, that's interesting, but the relationship between you and Sam, you were in a submitter yourself, but he's asked you to provide the local context, that's right?
Yes.
Yes.
Well, I should go on to say that one of our volunteers, since our project going, there's been a lot of other projects being, created, and one of those is because the kōkako is spreading north into that dock block, and Sam's dad, he's been keen on getting involved, so we were able to, because we haven't got access into that Clifton Road area, he suggested we make a track from the main road, from the Ahititi, and go south towards managed area. So we did that. We got Doc to help us cut the track, and they put traps in, and he checks them quite regularly. He actually checked them on Saturday, and he identified the kōkako that are moving into that area. So that was Sam's dad. He's been quite good there.
So Sam lives up around that part of the world?
Sam's dad, he's got one of those batches up at the Tongapurutu.
Oh, along there, incredible spot there.
Yeah.
And that's where you mentioned you live at Tongapurutu too, or?
No, I live in Waitara.
Oh, Waitara, but
Sam's been dragging a lot of young people to get up there and do some of that volunteer trapping.
Yes.
Good.
And just for the other panel members, I think they know this, I was a original decision maker on the Mount Messenger project. So certainly heard all the evidence about the kōkako recovery program and the fact that Ngāti Tama's really kicked that off, and that, with the provisions around that, there's a lot of close working together between DOC and Whakakotahi and certainly Ngāti Tama as well. So having you here as someone that's worked on some of those projects is pretty interesting. Look, Sam does have...
And
community as well, yeah. Sam does have 4 or 5 photographs at the end of his evidence, and I think that would really help us just orientate ourselves. There's some figures at the back, right at the back of all the combined evidence. Thanks, Julie.
bit of land where the Whitecliffs Walkway is and the Waterstock Tunnel. The kōkaku are moving in there too, and recent Kiwi survey has seen there's quite a few Kiwis in there.
Kiwis as well.
Yeah.
Yes.
Access makes it difficult to get put in methods to eradicate those threats.
Yes.
We do get a few hunters coming from the north too. That hunters with dogs are quite a big threat to the Kiwis.
Yes.
And I like to keep an eye on who the hunters and make sure the dogs have got that, avian version training.
Yes.
When they come from the north, I don't know, coming in there makes that
difficult. Yes. One of the highlights of my life, I think, was part of that process. I had a long helicopter trip all around that whole area, and we went right and close to the cliffs where the tunnel was, and it's an incredible landscape, and just the history there. Yeah. So oozes history and really dramatic landscape. So look, here are the photos. One of the, perhaps can we just make that? There's an area that Sam's outlined in red. So that's the Paraninahi Conservation Area, approximate boundary. So this is the area that, and the interesting thing is that the marine reserve is just off the coast there as well. And the evidence I heard Mount Messenger is, as you said, that this is the only area in the West Coast we actually get unbroken ecological natural areas right from the top of the ranges right down to the coast. And that's quite interesting. But can you also tell us about the Three Sisters, that star? What's the Three Sisters refer to?
That star right up the top there.
Yes.
Yeah. I think it's down to one sister now.
Oh, this is yes, okay. Yeah. Yes.
There was three sisters, down to two, but
yes,
down to one now.
And there's a road that comes in from the north past the Tongarupurutu Batches, but then it's a dead end, isn't it?
There's a road there.
Yes.
However, there's a piece that's been falling into the sea and it has to go onto private land.
Oh, okay.
And that's where...
Yeah, that's where the lock gate is.
Yeah.
Okay, so let's go to the next slides, which I think show this. So this is where the road has been closed. And we did hear some evidence on Monday from the council team, or might have actually been yesterday morning, about some of the problems with the locks gate. So that's Clifton Road, and the next one shows us where the legal roads fall into the sea. In terms of the purple, and then there was a road that goes around over that, past that, but it's a lock gate there, so there's no public access there. That goes onto some private land, doesn't it?
Yes.
Yes. Okay. And just the next slide. So this is looking north to south.
Yep.
This is Clifton Road.
Yes. Yep.
And that's on the area that's currently open.
That's on. It's just closed.
That's part of the closed road that goes across that private land.
Yeah.
Yes. And the next slide, I think, is particularly interesting. This is the old tunnel. So tell us about that. That comes off the end of the beach. How long is that tunnel?
Oh, give me 80 metres.
Yes.
Quite long.
And you can still walk through it, can't you?
Yeah, you can. It's overgrown a bit, but you can get through it.
And that was a key part of the walkway as it was. You could actually walk through.
Our volunteers used to do that loop, go along the beach, come down through the tunnel, trip that trap line.
Okay, and just the last couple there, we're just trying to orientate ourselves. I think there might be a picture of you there. Is that right?
I can't see it probably from
Conrad, because there's Conrad O'Carroll and Tiaki Te Maori. Yeah.
Yep, it's me.
Yeah. And also the last one, which is, there's a press photo from someone inside the tunnel looking out. And just flick through the last ones, I think. It's along the roadway. There's a graphic image there, the next photo about the White Cliffs. Again from the beach, and this close-up of the track closed where there's no public access at the moment. So yes, look, that's been really good to chat through that with you, looking at those images. Other questions for Mr. O'Carroll, Commissioner Littlejohn?
No, thank you, Mr. O'Carroll. That's was very interesting. I guess the simple question I have is, apart from money and human power, what else is needed to reinstate this walkway? Is it access over private land? Is it?
Yes, it's that the northern neighbours made it very difficult many years, and he's able to use that piece that's fallen in, that's fallen away, use that to stop access many years now. I know
And
that.
has there been any discussion with the landowner about this from Ngāti Tama or any other deputations to the landowner?
When I first started this project, I used to go up through that area to work on that north boundary, on the pest management area. But then Russell tried to get recognition for some claims that he's been trying to claim, and I couldn't do that. He was claiming kaitiaki status and mana whenua status, and every time I went onto his land, he would call that recognition, and I couldn't do that anymore, because I don't recognise them as.
So who's the person who owns it?
Russell Gibbs.
And how much track length is sort of missing? 100 metres, half a kilometre? To connect them up.
The bit that's fallen into the sea, that's worn away, it would be 100 to 150 metres.
Okay.
I haven't been up there for a while, so it might have worn away.
Okay. And that's the only portion that is sort of preventing the full public access, or presumably there's another bit further north on private land that would need to be opened up, or is that just that small area, is it?
As far as I know, it's just that small area where the lock gate is.
So have you got on the image 2 that was attached to Mr. Dixon's presentation, there's a point at the south which is locked gate, and then there's a picture to the north which is the tracked closed sign. So as I understand you correctly, the only bit where there is a barrier to connecting the two, image 2, I think. Yeah, the only bit that's the barrier is down just to where the red deviation would be required. Is that right?
That picture where it says track closed, that's not where the where it's fallen away. It's just at the end of the road. That's still public road, that piece. And you go down the track about another, maybe not quite a kilometre, where you get to that piece where you go onto the private road.
So that just happens to be a sign that's on a gate to tell you that the track down the road is closed.
I haven't been up there for a while. But yeah, like when I was going up there into that piece there, and it's just signs.
Is the rest of the purple, is that public road as well?
Yep.
Going north
Yes,
Yes.
so going south.
or going south.
Yep, I think it is.
Yeah.
Okay.
Yeah.
Yep.
Or paper road anyway, isn't it?
Yes.
Yeah. Okay.
When you get to where the Horde of Stuck tunnel is, there's quite a bit of road reserve there, but I'm too clear on the boundaries.
Just actually by reference to the plan that's up on the screen there, Mr. Carroll, where's the Stock Tunnel? Is it further south again, is it?
From that photo, yes.
Okay.
I think it could be right at the bottom of that. Can't see.
Oh, okay, right there. It's, yeah. Yeah, on the first plan, you can see image 1. It's much further south there, isn't it? Locked gate. Yeah, okay. Is the Stock Tunnel currently closed? Could you go through it right? Could you go through it at the moment?
It's closed, but you can get through it. Yeah.
Okay. And is it dangerous?
Not for me, but I've had guys take the horses through there.
Fair enough. I mean, danger is all relative. I mean, we all have different risk profiles. Okay. And the Stock Tunnel goes through Paper Road as well, is that right?
Not sure on that.
Okay, all right, I can track that down. Oh, look, that's been really helpful. So there's only really from connecting the two ends of the public road together, there's that erosion problem, and then you've got about 150 meters where you'd have to deviate further landward to be able to connect the two up. Would it be a fairly easy exercise to do that, do you think? And I mean, assuming Mr. Gibbs was cooperative, would it be difficult to connect the two ends together? I mean, would you need lots of earthworks? Is it a steep face? Would it require anything other than just a bit of gravel down?
I don't think it would be difficult at all. The difficulty would be dealing with
Mr. Gibbs. Okay.
yes, Mr. Gibbs.
Kapai. Well, look, that's been very helpful. I appreciate that. Thank you.
Mr. Coffin?
That answers most of my questions. I just had one other question, and it was just around the Te Aki Te Māori or Paranenehi Trust, and just in your evidence it says it do work on the Paranenehi block. So do you do work inland of this area, particularly? I'm assuming so, but I just want to clarify that.
Yeah. So I'm on the Runanga.
Oh yes.
Well, and I am the project manager for the Paranenehi project. Te Aki Te Māori or Paranenehi Trust, the administrative body for that Paranenehi project, is management and biodiversity. That they work. Their thing is to work as an iwi restoration project on behalf of Ngāti Tama and in the community.
So that pest management, is that over the whole block?
Over that red block here.
Yep. Thank you. How many members in the? Is it a membership of the trust, or is it a trust set up for a particular purpose?
The trust is the administration body for that pest management project. There's currently 9 trustees, 8 or 9.
Thank you.
Before, just one supplementary, how many people are working on the project, Conrad?
At the moment, I've got 2 full-time guys. I've dragged in these Mount Messenger staff to help me out with some Okako monitoring this morning, actually. And I've got a bunch of contractors that do a lot of track work and pest management tasks.
Yeah, Commissioner McMahon.
Yes, good afternoon, Mr. O'Carroll. Thanks for coming along. I had some questions for Mr. Dixon, and it's probably unfair of me to put them to you. I guess the thing that's sitting with me is Mr. Dixon's submission asks that the White Cliffs walkway should be included and mapped as a PAC, public access walkway, in the district plan. And he says that that would be a logical strategic step in planning and providing for this access over the long term, would help with long-term funding and that sort of thing. I'm getting the impression from you that there's going to be a need for more than that. There's going to be a need for some cooperation from third parties also, that just putting the walkway into that PAC status on its own won't cut the mustard. Would you agree with that?
Are you talking about walking access?
I'm talking about legal access. So it's one thing to have the walkway shown in the district plan as part of the PAC public access network. Another thing to actually have legal rights over that land to enable people to access it.
I'm not sure if got enough legal else to answer that. I know there's easement, or there was easement, in is that the pipe follows that walkway?
Yes.
Easement.
The first case one.
First case. I'm not too sure.
Yes.
The dock one. I think that could be the walking access inland easement. I'm not sure on that.
Okay. Well, as I said, it was probably a question for Mr. Dixon, but I won't take that any further. Thanks for your help.
Yes, and thank you very much, Conrad. It's been a pleasure to meet you, and really appreciate, obviously, the great work you're doing and around there. It's becoming really well known around the country, the Kokako project and what you're doing there. So fantastic work. Thank you very much.
Thank you.
Right. Patiently waiting, I think, is Ms. Hepplethwaite and Mr. Catchpole for Waka Kotahi. Can you just turn your videos on and we'll see you there.
Kia ora koutou, everybody. I'm not sure where Alan is. Alan, can you hear us?
I'm certainly here. I've lost video.
Okay. Would it please the panel if I commenced and Alan would be available to just answer questions? Thank you.
Yes, it sounds like we're going to hear Alan loud and clear, so we should be able to, if he's following us, Alan.
Yes, thank you, sir.
Yep.
Excellent. Kia ora koutou, everybody. My name's Kathy Hepplethwaite. I'm a planning consultant, and today I am appearing in support of the submission made by Waka Kotahi. This morning I circulated a brief summary of statement, and if it pleases the commissioners, I will just briefly read that. I assume that may be in front of you, sir.
Yes, thank you.
Excellent. If I could perhaps start at 1.4, which commences the summary of my primary evidence. 1.2 and 1.3, just confirming my qualifications and my continued adherence to the Code of Conduct.
Thank you.
I support the Ecosystems and Indigenous Biodiversity chapter. I support a new objective to recognise that some activities in some circumstances may be acceptable in significant natural areas, and also to provide support for Ms. Macbeth's proposed change to Policy 4. I have provided there and underlining the proposed new objective, which I would think appropriate. I consider that Policy 2 needs an amendment to include a new defined term, being regional biodiversity value, to ensure that policy 2 applies to areas of biodiversity which are able to be identified and have value rather than any Indigenous habitat or ecosystem regardless of value. Now, the latter there, the regardless of value, is what I consider policy 2 currently says, and my amendment seeks to clarify that it is areas of recognised and identifiable value that should be captured by policy 2. Now, following in from that statement, I have reproduced changes I support for policy 2 and also a new definition, which was included in Waka Kotahi's primary submission. On review of that, I have suggested a couple of minor amendments which are reflected there in bold text. I acknowledge the changes proposed by Ms Macbeth to policy 4. However, I prefer alternative wording, which I consider more closely reflects the requirements of the New Zealand Coastal Policy Statement 11. Following that is an underlined addition. I've taken Ms Macbeth's policy 4 and suggested that 1A be included. For paragraph 1.7, this is an administrative matter more than anything. Waka Kotahi sought that a site ID 336 from Schedule 6, sorry, 337 from Schedule 6 should be removed, and it was supported by the evidence of Ms Herbert. I think it's just an oversight which may have been omitted from Ms Macbeth's recommendations, and just draw that to the panel's attention for their consideration as they move forward. Turning now to the Waterbodies chapter, Ms Macbeth has recommended the inclusion of the word operational after functional in policy 3, subsection 2, and I agree with her proposal, as there are often operational requirements for infrastructure. For the natural features, landscapes and public access and Waterbodies chapters combined, we may have had a slight misunderstanding or be at cross purposes with the submission. Waka Kotahi sought some clarification about how and or would be utilised throughout the whole plan and made a whole of plan submission. The authors of the chapter provisions have very thoughtfully gone through and made those amendments on a chapter by chapter basis. As the primary author of the Waka Kotahi submission, the submission was generally aimed at a whole of chapter solution in the sort of the how the plan works section that says if things appear in a list, they are always and unless otherwise specified, or whatever the council's wish was. I put that forward only as an example as the relief sought. So really just drawing that to your attention to both recognise the efforts that the section 42A authors have put to the details of that. My primary evidence indicates I have no concerns with the amendments they propose, but also so that the matter is not overlooked on a plan-wide basis, and that the issue of and or is addressed, or alternatively, if I've missed it somewhere in the plan review, then I would be grateful to have that pointed out. I don't think that's the case, but you know, not bulletproof here. So that's just a broader item there in paragraphs 1.9 and 1.10. That was all I had today, sir, so I'm happy to answer any questions as Mr. Catchpole.
Thank you very much. We were getting a bit of feedback. Has that gone away by the look of things? Sounds like it has. So thank you. Commissioner Littlejohn, do you have any questions?
Am I off mute? Oh, I am. All right, good. Yeah, just your new objective. This is the only one I wanted to have a quick chatty about. Your evidence, as usual, was crystal clear and aimed to please. So I appreciate that, Ms. Hepplethwaite. The suggestion of a new objective is essentially to provide, as you say, to provide support for Eco P4. And I'm just wondering if you got Eco P4 in front of you?
One moment, sir, I will have that.
Yeah, just the revised version that's been put forward by Ms. Macbeth.
Yes, I have.
And it's something I was going to bring up with Ms. Macbeth later, but it might be quite useful to get your take on it as well. The way I'd read the policy, particularly I guess the starting phrase to it, is that it was really just focused on the coastal environment. Do you read that? Do you read it like that?
Yes, I would agree with that.
So this is intending to address the, I guess, the NZCPS policy 11 issue, and I guess to some extent, yeah, that sort of stuff. It then has the management techniques are twofold. One, avoid significant adverse effects in the coastal environment, and then secondly, for other adverse effects. Now, this is the question I was going to put to Ms. Macbeth, but my assumption was that the for other adverse effects is really it's just an abbreviation to say for other adverse effects on natural areas in the coastal environment, because it's a policy about coastal environment. Is that how you read it? Yeah.
Yes.
Okay. So then coming to your objective, then it's much broader than just the coastal environment, and I'm wondering whether it needs to be reconsidered on the assumption that it's linking to the new policy 4 to really just confine itself to be a policy about what the council's objective is with respect to significant natural areas in the coastal environment per se.
The purpose of the new objective is to assist with support of policy 4. And if you just bear with me a moment, and I might just put myself on mute because when I rustle through my primary submission, it's going to be noisy. But there is, from my recollection, other there've been other changes to the policy construct. Initially, they were. Actually, I will just have them in front of me. A moment.
Just while you're looking at that, through you, Mr. Chair, Kit, my reading of Eco P4 and Ms. Macbeth's version would suggest that P4 is not limited to just the coastal environment. It says ensure the adverse effects of activities on SNAs or Indigenous vegetation. Or Indigenous vegetation doesn't quite make sense. The coastal environment, is there a word missing?
I guess the critical word that's missing is that conjunction after vegetation. Is it a within or is it an in to some extent?
Yes, I must admit I read it as ensure the adverse effects on significant natural areas or Indigenous vegetation in the coastal environment. And so I thought that policy applied to both SNAs and the coastal environment. So
yes, SNAs. Well, I saw it differently, but maybe that's what we should get Ms. Macbeth to clarify. Yes, exactly. I'd understood that the policies had been restructured to focus on general SNAs and then a more specific focused policy to deal with the NZCPS on the coastal environment.
Kit, if you look at the crossed out part of policy 4 to start with, that there might be the answer in that first line.
Well, possibly, David.
Could I suggest Ms. Macbeth is poised to clarify, so that might be a good way to just contribute to the discussion.
Thank you. The intention is that P4 applies to the coastal environment and SNAs, and clause 1 is a specific response to policy 11 of the NZCPS, and then 2 includes other requirements of the NZCPS as well as applying to all SNAs. That's the intention, and I acknowledge that there's a word missing there in the first line.
Yes.
Okay. All right. Well, that sort of resolved the issue I had with Ms. Hepplethwaite and the breadth of her proposed Waka Kotahi's objective. So, Ms. Hepplethwaite, I don't know whether you want to go further on this.
I don't think that's necessary at this stage, sir. Unless you would like me to.
So, Ms. Macbeth, would it be better to clarify this to, rather than use the word or as the conjunction between the significant natural areas and Indigenous vegetation, we have an and then it's either a within or an in the coastal environment.
I
What would
agree. I would say significant natural areas and Indigenous vegetation in the coastal environment.
Okay, and then we can use, then we've got two different creatures we're talking about. We're talking about the significant natural areas and as a separate construct, the Indigenous vegetation in the coastal environment.
Yep.
Yes.
Okay. Or I'm still going to repeat that to myself as I go to sleep tonight to see if it makes sense, but that's not something I need to concern you all with. Ms. Hepplethwaite, I think that was the only matter I really just wanted to check with you. The objective refers to special circumstances, so I'm presuming that when we look to see where that gets translated through into the policy, what are the special circumstances that are being identified for environmental compensation?
The policy as proposed by Ms. McBeath, it's specific circumstances.
Sorry, yep.
And I'll just pointing that out because special circumstances obviously have its own meaning in the context. The policy proposed by Ms. McBeath in P4, we've got obviously the avoid, remedy, mitigate, offset or compensate hierarchy, which is
so that's the reference you're making there. The specific circumstances is the circumstances that arise by following that hierarchy.
Yes.
Is that okay?
And it will require a case-by-case assessment on each application that falls within the ambit of that policy and the consent frame, the rule framework. So it's just really recognising that in some cases it will be appropriate, in other cases it will not be.
Okay. No, look, that's helpful. Thank you.
Commissioner Coffin.
I didn't have the other questions.
Commissioner McMahon.
Yeah, good afternoon, Ms. Hepplethwaite. Just for me, it's really your new objective also. And I've had a look at it and just putting my planning lens on, I wonder whether it's actually constructed as an objective and that it has an outcome or a goal, and as opposed to whether it's more of a how and method style of writing that might be better suited to a policy. And I just wondered from a planning perspective what your response to that might be. I'm not arguing about the merits or otherwise of the objective, it's just how it's cast in terms of how something might be achieved as opposed to what the end result might be.
That's a good question, Sir.
Thank you.
The language could be altered somewhat to be more objective-like, if that is a phrase.
Okay.
I'm reasonably comfortable with it, but it's the intent that I'd most like to see retained if the wording is altered to make it, in the Commission's view, more appropriate.
Yes.
I wouldn't have any objection.
Yeah. In terms of that intent, I'm just wondering, in light of the clarification provided from Ms. McBeath as to what the policy P4 relates to, and also what policy 3 relates to, is it possible, in your view, that P3 and P4 actually replicate the intent that you've included in that objective, and that the objective or quasi policy already exists in some form and through P3 and P4?
I think where I saw the gap was not so much that the existing policies were wildly inadequate, it was more that the objectives didn't recognise that there would be some activities which were able to be or provided for via consenting undertaken within the SNA and coastal environment. Objective 1 talks about protection and enhancement. Objective 2 talks about biodiversity being maintained and where appropriate enhanced. And objective 3 refers to the relationship of tangata whenua. There's nothing in that suite of 3 objectives which describes to me that some activities will be able to be undertaken at some time where appropriate mitigation is available as necessary.
Yes, you're quite right. And on day 1, we took this up with the reporting officer, Ms. Macbeth, and she explained to us that was intentional, that the objective is, in her view, best focused on identification and protection. And she acknowledged that the wording on the objective, particularly objective 1, does not replicate the wording in section 6C of the Act. And she explained to us that not only was that intentional, but she saw the role of policies as doing the heavy work and defining what activities might be appropriate or not inappropriate in terms of protection of Indigenous biodiversity or Indigenous vegetation. And so what we see is, and is a careful focus in the policies as to what might be deemed to be appropriate activities. And she said that what I got from Ms. Macbeth's presentation and the questioning of her was that was a very intentional process. It left the objective to state an outcome and the policies to do the work and nuancing how that objective might be achieved and what the exceptions, if that's the right word, or what the activities that might be appropriate or not inappropriate might be. And I'm not sure whether you sat in on some of those earlier sessions, but there was a very clear message that I received from Ms. Macbeth, and it was an intentional focus on keeping the objectives simple, protection orientated in the policies, providing a little bit of wiggle room to give effect to section 6C. And I just wondered if you've got a response to that at all. In terms of, the question I put to Ms. Macbeth is that an effective and efficient way of giving effect to section 6C? And she felt it was.
I didn't sit in on the first day, sir. This is my first attendance at hearing 5. So thank you for filling in the previous proceedings on that. There is quite a range of permitted, and acknowledging that the policies do provide for other outcomes beyond protection and enhancement. There is a range of permitted activities in the rule set. They're not broad, I will give you that, but yes, there is a variety of those there. And at the moment, if you follow the cascade from the top, I don't think there's sufficient support to recognise those. If there were no permitted activities and they all required consent, then maybe, but there clearly, I think, needs to be a link from the top down, and there isn't, as I see it at the moment.
Okay, I understand what you're saying. Can I put that to you slightly differently? One submitter, sorry, I can't remember who it was, suggested that the objective 1 should be altered to replicate the wording in section 6C. So it's protection from inappropriate subdivision use and development. If that alteration was made, would that make the objective package more complete and the policies that then sit underneath it more conjoined, if you like?
That would be a helpful addition. I'd like to just probably have a further think about that, whether, it requires a judgment then of inappropriate, which the policies and following methods would actually provide you with some support and some direction on. So
I guess the question in my mind is whether those words are necessary to assist the policy interpretation, or whether the policy can do the heavy working. The goal of protection's obviously of paramount. Whether the qualification of that protection needs to be included in the objective in addition to the policies, I guess is the moot point, and I don't have a view on it one way or the other. That's why I'm putting it to you.
Yeah, well, I quite clearly said I consider an objective and it's necessary, acknowledging your points that it could be more objective-ish, if that's a wish, including the words I think you said inappropriate development would go some way towards that. My preference probably remains, without having the chance to have a good think about that, to have a separate objective. Provision of infrastructure is obviously a fairly important matter. It's not recognised in Section 6, clearly, but it is something which is reflected in the detail of the policies and rules that follow down from the objectives.
Yes, and I presume the lawmakers, when they drafted Section 6, were of a view that what constitutes appropriate or inappropriate development will be decided on a case-by-case basis with a spatial overlay considered. Yes, okay. Thank you. And the only other thing I had, and your summary was very good. Thank you for that. On your last page, and it's pedantic, but in 1.8 you referred to Miss Macbeth, and I think that should be Miss Young, was the author of the Waterbodies chapter.
Oh, my apologies, sir, and please take that as a correction and an error on my behalf.
Thank you.
Thank you, Hebblethwaite. I do have one just clarification about the and/or point you've come back to. Not sure that I've got the gist of all this, because I think in the strategic directions chapter we were quite interested in, didn't really like and/ors, and we're looking for one or the other, because that's, we thought, would assist plan interpretation. Is that right? Is that the request?
Sarah, if I could clarify that, I agree with you, and I don't think and/or is helpful drafting. And I again acknowledge the planners have sought to clarify that in these particular chapters. My request was, or the submission which I drafted, was on the basis of you don't need to write and/or after every list if at the start of the plan there is an overarching statement that says all lists are ands or ors, depending on what the council wishes are, unless otherwise specified. So when a reader is using the plan, if there is a list of 6 things with semicolons at the end of each sentence, a provision earlier in the plan says they are all and things, they are to be read conjunctively. Or alternatively, a rule at the start of the plan says all of those things on the list are ors, unless they say otherwise. So I was looking for a whole of plan response, so that when one encounters a list that's numeric in the plan, you knew automatically that it was a conjunctive list or a separate item list.
Okay, that helps. Terrible feedback. Are you hearing that as well?
I'll mute. I suspect it might be my sound today. I haven't got earphones available.
Okay. Just a clarification from Ms. Young. You've given us the updates with and/ors put back. Is this the same issue, or am I?
It's the same issue. It should have just been at the end. So in I think in the Waterbodies chapter, there is actually a list and it's got and or at the last. And so I've corrected that to be an or.
Oh, right.
But then I misinterpreted that and thought that I then had to correct the and/ors that were in the text of the policies, and I did actually spend quite a lot of time doing that, but then realised I was out of scope.
Oh, all right.
Yeah.
Okay. I'll be thinking about and/or as I drift off to sleep tonight, because yes, so look, that is clarification. Look, one last procedural matter, Ms. Hebblethwaite. We have asked for the track change version to come to us on top of the officer's recommendations. That was in minute 3 or 4, where all of the practitioners are now giving us as we've asked for, basically further additions that you'd like to see on top of the 42A version of the provisions. So could you provide that for us, because that's a key. Those are key documents when we're deliberating. Do you understand what I'm saying there?
Sue, could I just clarify? I thought I had included that in my summary statement, but
I couldn't see that.
But are you expecting a full revision of the chapter in the same format as the council planners, perhaps as an addenda to the summary report versus being inside the evidence?
Yes, we asked for that in a minute. It's just that when we were looking at provisions, the colour coding does help, and all the other practitioners are providing an appendix which actually shows the 42A reporters in blue highlighting and the additional matters in red highlighting. So we gave an example of one that we thought was really helpful after hearing number one. So if you could just provide that to us and send it to the hearings administrators.
Yes, sir, and my apologies. I took that to, you did request that last time, and I took that to mean to include the text rather than follow the detailed format. So I will ensure that
it doesn't matter. No, it doesn't matter either way. But maybe my my copy here hasn't been printed off.
It's not in colour, sir. It's only in black and white. You're not misreading.
Yeah.
I didn't appreciate you wanted the colour. I will attend to that.
It's a pedantic point, but those are so helpful to us. As you appreciate, we've got dozens and dozens of different versions, and that's a really great aid memoir for us.
Yeah, so, no, definitely, sir. And my apologies for not picking up on that detail. That'll be with you later today.
Thank you. And I've just been reminded that we also asked in the procedures that any changes that are proposed are supported by 32AA analysis, because if that's not done, we're left trying to make it up ourselves. So in terms of just as again, it's a specific request. So sorry to put you to more work, but that's what we are requiring.
No problem, sir. Oh, that'll be provided too. That may now be tomorrow though. Okay. Is that for all matters which a submission has been made on, or only further changes to the council planning report? The 42 report.
I think it's your position on top of the 42A. Like if you've actually accepted some things and you're still seeking some further changes, just that process of going through 32AA, thinking about the costs and benefits and risks and all those matters, it can be quite brief and very, as you are, you're very to the point. So we're not looking for a magnus opus or anything. It's just the process of thinking about that.
Certainly, sir, no problem.
Thank you very much. Thank you. So I think that's your position. Any other comments, Mr. Catchpole?
No, thank you, Mr. Chairman. That's excellent.
Thank you very much. Right, we are now moving to Trustpower, who I think are here. Yes. McFarlane Hill, will you kick off? Yes.
I'm Miss McFarlane Hill, sorry.
Yes.
Yes, I can kick off.
Thank you.
Ko tanga te titi, ko tanga te kaka, tangi hoki aho, i hei mauri ora. O whakawhanaki tuku maonga, ko rakaturi tuku awa, o kura haupo tuku waka, ko rongo mai wahine tuku iwi, o erepeti tuku marae, no mahia aho. E tauranga tuku kāinga i nāne, Ko McFarlane Hill tuku whānau, ko Shelby taku ingoa. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa.
Thank you.
Hello, Commissioners. My name is Shelby McFarlane Hill, and I am an Environmental Policy Advisor with Trustpower. Sorry. I trust that you've all been able to read my full company evidence dated the 24th of September, to which I have prepared a brief summary to talk to now.
And thank you very much.
Trustpower owns and operates the Mangere and Mochikawa hydroelectric power schemes within the New Plymouth district. The Mangere scheme is relatively straightforward, wherein the Mangamahoe stream has been dammed to create Lake Mangamahoe, where water feeds into the power station intake near the lake lookout and travels along approximately 2 kilometres of tunnels and penstocks before moving through the station and being discharged into the Waitaka-Iho River. The Mochikawa scheme is slightly more complex, wherein Trustpower takes water from the Manganui River and transports it via a 4.5 kilometre race to Lake Ratapico, which was dammed, created by damming the Mako stream. And at the easternmost point of this lake, the water passes into an intake tunnel and travels approximately 4 kilometres to the Mochikawa power station. Here, the water is then discharged to the Makara stream once passing through our generators. As you can understand by these descriptions, the environments that Trustpower operates in can vary geographically and in complexity. However, a common factor amongst both of the schemes and all hydro schemes across the country is the natural environment which surrounds them. While there is no doubt that there are areas of natural character and Indigenous biodiversity that surrounds our schemes, Trustpower's submission focuses on the fact that there is a functional and operational need for its infrastructure to locate where the resource is available. This in turn extends to the flora and fauna that also rely on locating around the freshwater resource. This is particularly relevant for the Mangere scheme, which has an SNA overhanging parts of its tail race. Trustpower has been consulted on this since 2016 and has maintained the same stance since, being that the SNA boundary be pushed back to align with Trustpower's property boundary. This will allow us to develop, operate, maintain, and upgrade our infrastructure within this area. Outside of this specific area, Trustpower has submitted in its evidence that there needs to be a consenting pathway for infrastructure that has an operational or functional need to locate within these environments, where the works are not limited to maintenance or repair. For questions around Trustpower's specific relief sought, I would direct you to Renee Calland, our expert planner. Otherwise, I'm happy to answer any questions that you might have around our schemes.
Yes, thank you very much, Shelby. I'm a very visual spatial person, so I've had put up on the screen, firstly, Mangere, which you just talk us through again, just looking at the picture.
Sure.
Yep.
So Lake Mangamahoe, we have an intake to the river on my right, which is Lake Whakaiho. The Waitaka-Iho River. And that feeds into Lake Mangamahoe. And then if you follow the white arrows up the diagram, you see that we have an intake just on the northernmost point of the lake where there's that little ditch that goes through to our tunnels and penstock and comes through to the the Mangere power station, which is near the top of the page there. And then it's discharged through our tail race and rejoins the Waitaka. Sorry, am I saying that right? Yes, the Waitaka-Iho River.
So, so the purple dashes are actually tunnels.
The dotted line?
The dotted lines.
Yes,
Yes.
tunnel. Yes, that one there is a tunnel, and then the white line is a penstock, I believe.
And the lake, Lake Mangamahoe, is that a natural lake or is that, that's already there?
It was the Mangamahoe stream. I believe I said in my evidence, the lower at 4.2, the lower dam on the Mangamahoe stream was commissioned in 1918. So it's a bit of an old one.
Yes.
With the original power station being commissioned in 1904, I believe.
Yes, I presume there's residual flows below your scheme intake. You can't take the whole.
No, so that's in the Waiwhakaiho River, correct, residual flows. We also have fish pass there.
Okay. So should we go to the next scheme, which is the one which you're concerned about, the SNA, is that right?
No, other way around.
It's the other way around. All right, can we go then back to the other one? So it's where you have you're discharging from the power station back to the river. This is where the problem.
Yeah,
this is where the issue is.
Right at the top of the diagram, there's a purple box.
Yes.
It's around that area where the water is discharged from the power station into the Waiwhakaiho.
Okay. And that's this SNA 260.
Yes.
Right. Thank you. And just a quick look at the other one, because these old power schemes fascinate me.
Yep.
I'll flip that around, I think. Here we go.
So our original intake is on the leftmost of the screen from the Manganui River. And we also have a fish pass at our intake there. From there, the water enters the Ailing settling pond and is then transported along those races, which are the purple lines, I believe, up to Lake Ratapico. Lake Ratapico, I believe, was not a natural lake. We've dammed that. And at the easternmost point of that lake, it goes through tunnels again, and then penstocks in our power station, and then is released into the Makara stream.
Thank you. It just provides a really good context for us. Appreciate that.
Thank you.
So I'll ask the other commissioners if you have any questions. Commissioner Littlejohn.
I guess just a really simple one. There's a real echo. The concern with SNA 260 is around your need to potentially upgrade the existing infrastructure. Have you given any thought to how much, if any, vegetation might need to be modified to enable your plans for the foreseeable future in that area?
We don't have any specific plans for upgrades that are going to happen in the next few years, but it's just that we don't want to rule out the possibility in the future that we might want to do upgrades. We went on a site visit there this morning and just to have a better look than what Google Earth can provide us. And we found that there is, the river level was quite high, I think, or the tail race was quite high this morning. There's quite a lot of vegetation along the side there. And if we did in the future need to strengthen the tail race to make sure that there wasn't any sediment erosion or any safety concerns in the future, we don't want to rule the possibility of that out.
Okay.
If I may, Councillor, Commissioner Littlejohn, the widest part of that is about 13 metres from the tail race to the truss power boundary, and then it tapers both ways.
Okay. Okay. Oh, look, my other questions were going to be around the legal authorizations for it, but I'll ask Ms. Calland about that. So thank you for your evidence. It was helpful.
Thank you.
My questions was, I just asked the administration just to bring up the SNA, because it would be worthwhile actually seeing exactly where it is, because I've been involved in cases which involve hydro infrastructure structures.
Sorry, is this the right one?
There's a map in my evidence in Appendix B of the SNA, if that helps.
Oh, okay.
Well, we can see it on the screen too, can't we? Okay. Yeah. So perhaps bring that back up again.
The appendix.
So this is just part of the overall SNA, isn't it?
Yes, so,
This is the area that...
so that orange line there shows the Trustpower boundary, and the boundary of the SNA is on the tail race.
Okay. But my question was back to that original, it's a much larger than what we're seeing here, the overall SNA. Yes, thank you. Oh, just while we're talking, to get the full extent back up. Commissioner, have you?
Yeah, I just wanted to just understand the context a bit better, because in some of the hydro schemes you have an area where when they built it, there was actually no vegetation there, and the vegetation has actually been regenerated as a result from the surrounding forest over a period of time. And so you've ended up with regenerated bush where there was actually, I was going to say scorched earth, but where the project footprint was. And then over time it has been maintained, or for whatever reason it hasn't been maintained, and then regeneration has happened. I just want to understand. And sometimes there's actually different composition of the in this case bush that's next to those infrastructures as opposed to further to the SNA, but I'm not getting that sense from this particular, or the edge of it.
So closer to our outlet,
yes.
As it's reflected in the SNA there, it is a lot more barren. There's not as much vegetation there, but it's as you get to the end of the SNA, the end of the tail race, which is reflected in the SNA, that's where more vegetation pops up.
Okay.
The scheme, as I mentioned earlier, was originally commissioned in 1906, so it is very likely that some bush has regenerated around it in the course of the scheme's lifetime. Yeah.
Okay. Thank you, Commissioner McMahon.
Yes. Sorry, I'm trying not to jump to the chase here. I'll leave my questions to you, Ms. McFarlane. I take it that Trustpower is not challenging whether the SNA qualifies for inclusion. You're not leading any ecological evidence to challenge that, are you?
No, we purely want recognition of the functional and operational need to locate in that location.
Okay. Right. Okay. And so I will cut to the chase then. So I mean, it's an either or scenario, isn't it? Either the boundary of the SNA is altered, and therefore you're not bound by those rules, or If it's not altered, then you'd like the rules to make some provision for activities other than just maintenance and repair. That's it in a nutshell?
In a nutshell, yes.
Yes.
My personal opinion, if I'm allowed to give that, is that there should be recognition or a consenting pathway within the rest of the plan for those activities that go beyond maintenance and repair.
Yes.
For infrastructure that has a functional and operational need to locate.
Yes. I guess you wouldn't be here today though if the boundary was in a different position.
We might be. I wouldn't rule it out.
Okay. Okay. Sorry. You mentioned earlier that there's no immediate plans over the next few years for any works other than maintenance and repair. What about during the life of the plan? I presume a company like Trustpower has asset management plans and long-term maintenance and development plans that would encompass more than a few years. Is there anything on the horizon that would equate to the life of the district plan?
Not necessarily that I'm privy to in my role as a policy advisor. That might be more an enhancements engineer question.
Above your pay grade?
Might be.
Above us all, probably.
I guess that also depends on what the life of the plan is going to be in light of the legislation.
Yeah, let's assume 10 to 15 years.
Yeah. I think the other thing to note would be that if we did need to do works in this area, it might not be something that would be planned, i.e. if we had a collapse or something happened, but that would fall more under emergency works.
Okay. So I just take you back to your preference, and I'll ask the same question of the planner also. Is the preference that the boundary be squared off and comes back to the property boundary, or is the preference that the SNA remain and that there's an alteration to the policies and rules to provide the consenting pathway?
The SNA be pushed back.
Okay, thank you.
Right. And I have no further questions. So over to you, Ms. Calland.
Thank you. Kia ora koutou. Ko o te monga, ko tauranga te moana, ko ota tahi ahau, ko suka toku waka, ko raumai toku ingawa, ke TNT ahau e mahi ana, no reira, tēnā koutou katoa.
Kia ora.
Thank you for the opportunity to appear before you today. I have written some notes, which I'm going to deviate a little bit from because of the discussion we've already had. So please bear with me a little bit. And I do acknowledge that you asked for copies of these to be provided, but I was editing after our site visit this morning as well.
Just pop them through when you get back to the office.
Okay, thank you.
I don't need to apologise for rummaging around trying to look for it.
And I understand my evidence has been pre-circulated and that I don't need to run you through that, but I do have some key points that I would like to highlight. You've heard from Ms. McFarlane-Hill and her comment on the functional and operational needs for the location of Trustpower's assets and the importance of enabling the ongoing operation, maintenance and upgrades in these locations. As hydroelectric power generators, these locations are adjacent to water resources, and specifically in this case, the Mangarae and Otukawa schemes that Ms. McFarlane-Hill's described to you. This in itself can cause conflicting objectives and policies in the plan when considering other values such as significant natural areas, natural features and landscapes, as well as public access. And so I've suggested some amendments to help manage these conflicts that would then enable rather than frustrate Trustpower's activities while still giving regard to these other values. So firstly, I draw your attention to the fact that Trustpower is not classified as a network utility. And there are places in the plan that specifically allow for network utilities, which then doesn't cover Trustpower's activity. And for example, today when we were on site, we could see the power station here, and then just beyond the fence was PowerCo's substation. So PowerCo is a network utility because that's part of the distribution, but Trustpower is not a network utility because they're a generator and so aren't included in that definition. So there's the odd place in the plan where we've snuck in renewables as alongside the network utilities, and that's the reason for doing that. And then the other point in a similar vein is that Trustpower doesn't form part of the national grid. So they supply to the national grid but aren't part of the national grid. And there's policies in the natural features and landscapes chapter that addresses the national grid but doesn't look at the generation part of Trustpower's. And I've already mentioned that this morning we've been to site and looked at the SNA. And again, and Commissioner Little, no.
McMahon, this one.
Yes, sorry. Yes, me. Yes.
I'm honoured that you think I have the power of the law behind me.
Yeah, so you asked some questions about the tail race and where it sits in relation to the SNA, and so we've gone through those, and what we're looking at is the ability for Trustpower to undertake their activities in those locations. The one thing that we did notice is in the permitted activity rule that it talks about the maintenance of infrastructure. And so, and while it specifically also refers to network utilities, the tail race is clearly a piece of Trustpower's infrastructure. But I think that point's clouded a little bit because the tail race is also mapped as a water body in the mapping, and that's then referred to in the Waterbodies chapter. So I commented a little bit as well. So then we talked a little bit about being able to undertake maintenance, but there not being a clear consent pathway or any upgrades or work that may be required on the tail race, and that currently that only pathway is as a non-complying activity. And I don't consider that appropriate for regionally significant infrastructure. In my opinion, non-complying status should be reserved for activities that are not anticipated. And with the central government push to increase renewable energy generation, upgrades to increase efficiency and output from infrastructure, existing infrastructure should be anticipated and an appropriate consent pathway provided. I've therefore, if the boundary is not moved, suggested a restricted discretionary pathway for regionally significant infrastructure. And to that extent, I also put in a mission for regional infrastructure. So I'll now turn to offsetting, and we had requested a note, our wording be added around offsetting in relation to maintenance and enhancement of Indigenous biodiversity. So originally we had requested that text was included in the provisions, but now I've suggested that perhaps it would be included as a note And the trust power fully accepts the effects management hierarchy of avoid, remedy, minimise in that order, followed by offsetting and compensation. And so there's no intent to give primacy to offsetting. Rather, it's that offsetting can be a way to achieve the intent of those policies. Trust power respects the district's goals to enhance and maintain biodiversity within the rohe, and that and also consider that it's important to frame the plan provisions such that enhancement is achieved on a district-wide basis, while accepting that some sites or activities may not be able to achieve enhancement. Consequently, I've recommended or requested, that policy Eco P6 and the definition for biodiversity offset retain the wording as notified. That's no net loss and preferably a net gain of Indigenous biodiversity rather than requiring a net gain. And that's maybe to achieve on a site-by-site basis. It's important that regionally significant infrastructure is enabled within the district, and as mentioned, I've put forward a definition to that, as well as the restricted discretionary activity in ER1. Trust power supports public access within the district, but also needs to ensure the health and safety and well-being of parties visiting their sites. Consequently, there are times that public access may need to be restricted, and so I've suggested the inclusion of a new policy in the public access chapter to allow for those situations. And that's mainly come about because there's a public access corridor adjacent to the Mangere tail race. So, and in fact, we walked along it today. But there may be times that trust powers in there doing work and may need to restrict that access from a health and safety. And lastly, I turn to the Waterbodies chapter. As a hydroelectric power generator, trust powers assets and activities are located in and adjacent to water bodies, natural and constructed. If this chapter is to be retained, it's important that only natural water bodies are mapped, and those that do not meet the definition of a water body, which includes a canal for the supply of water for electricity power generation, are not mapped. And so I've therefore recommended some changes to the mapping, and that's included at Appendix B in my evidence, where some of the races, including the tail race at Mangere, have been mapped as water body. I have also suggested that hydroelectric power schemes and activities specifically excluded from policy WB2, as well as rules WBR1 through to WBR4. All of these activities are already consented and controlled by Taranaki Regional Council, and to include them here could result in duplication of functions, added complexity, and the potential for conflicting compliance requirements. That's my summary, so happy to answer.
Thank you, Ms. Calland. I have to say that your evidence is excellent. It's very clear, and the use of the images and things has been a fair bit of work put into this. And I think that reflects the fact that we're dealing with some tricky schemes that have been around for a long time, lots of different parts and interactions with these eco chapters. So just like to thank you for that. I'll hand over to Commissioner Littlejohn to start any questions.
Good afternoon. Wishing I was there. Is just the first one, your suggested definition of regionally significant infrastructure. Is there a definition in the regional policy statement for regionally significant infrastructure, or does it sort of predate our general fascination with these things?
There's not one in the regional policy statement. When I've pulled one together, I've looked at other regional policy statements and seen the sorts of things that they've included, and hopefully have included most of the regionally significant infrastructure in the Taranaki region.
Well, I suspect that if you haven't, and it sort of gathers strength, everyone will want themselves on your list. But I think it's quite helpful because it's not defined at the moment, and it does the plan does take a very network utilities sort of approach to this, which is not generally the same thing as regionally significant infrastructure from my experience. So the other thing I wanted to talk to you about is really the approach that's been taken, and in particular the consenting pathway and how you sort of get through it, because I mean, this plan has unashamedly, if I understood Ms. Macbeth correctly, taken a very sort of hard line. I think she used the phrase precautionary. I sort of prefer to categorize it as very avoidance based, so that there very few things are permitted, and then you come up against a hard cliff or a hard edge of non-complying, and the policy assessment then determines whether you sort of get through it. And I know a lot of districts have had to confront this problem, and I think or this approach, and I think what you're suggesting is that you have your green and you have your red, but then in the middle you have your orange. And I think you're saying, in terms of a traffic light scenario, that regionally significant infrastructure sort of fits into the orange, hence another pathway that's not as abrupt as non-complying and certainly not as permissive as permitted. Is that where you see things going for your client?
Yes, I think that's a very good summary.
Ms. Macbeth, in her 42A report, did make a modification to policy P3, and she included the phrase, so it can be necessary for regionally significant infrastructure where there is no practicable alternative. And she didn't qualify that that activity by saying it had to be for existing, or that it was for operation or repair only. So I'd sort of taken it that was a recognition at a policy level that regionally significant infrastructure might need to do more than just operate, maintain and repair, and potentially might need to upgrade. Did you not read it like that?
Yes, I did. And in fact, I probably put in a bit of clarification where I inserted the word new regionally and regionally significant infrastructure, and then added a new clause E, which was for the operation, maintenance, repair and upgrade of regionally significant infrastructure. So just to clarify probably that very point that you've made.
Okay. So in the scenario for new regionally significant infrastructure, let's say for whatever reason, and I know I think the Mount Messenger case is a prime example of where it can only go through a significant natural area. And assuming there was no change to the rules, the regionally significant infrastructure would find itself as a non-complying activity, and it would then have to look at the policy framework. So at first blush, by putting those requirements in there, it would at least get through the requirement that it not be contrary to the policy. Is that how you see it would work?
So could you repeat that? I'm not quite sure.
Yeah. I'm just trying to imagine what we talk about as the consent pathway. Let's assume there's no changes to the rules, and that new regionally significant infrastructure needs to disturb an SNA for whatever reason. It it has to seek a resource consent. The resource consent's non-complying because it's not provided for under the rules. The policy P3 that then becomes, I guess, the core measure for the contrariness test in section 104D. Is that how you see it would work?
Yes, and I think and part of the reasoning for differentiating between new regionally significant infrastructure and the upgrades is in the new regionally significant infrastructure, you need to be able to demonstrate that there's no practicable alternative, whereas I didn't include that proviso for the operation, maintenance, repair and upgrade of regionally significant existing infrastructure. And I think that's probably the key difference between the two and the reason for that differentiation.
Okay. Oh, that's helpful. In that consenting scenario, is it your understanding that policy P4 would also be engaged in terms of any of the effects of that regionally significant infrastructure, so that it would still have to be measured against that policy as well?
Yes, so that's the management hierarchy, yes. Yeah, and I also heard your questions of Waka Kotahi earlier, and I'd read it as applying to SNAs as well as the coastal environment. That was my reading as well.
All right. Well, that's a great way of saying I need to read things carefully. Thank you for that. Commissioner McMahon's already pointed that out to me.
Yeah, well,
so,
least I could do.
Okay, so in that scenario, let's assume that it is a new regionally significant infrastructure. It's had to turn up with a non-complying application, but it's quite clear that there's no practicable alternative of it. It's got to be located in this area and some SNA has to go for it to happen. And then also let's assume that it's able to demonstrate that it's properly gone through the effects hierarchy and it's done all that it can do to be able to be consistent with that. In that scenario, it's essentially treated the same as a discretionary activity. You've got through the thresholds. And so I guess I asked the question, if that's truly the outcome, then what does making it by way of modification to the rules a restricted discretionary give you over and above a really good project that just has done very well to get through the policy framework? Why do you need to change the rules if you've put in place a policy framework that really good projects that have had that have been well thought through can actually get through?
A restricted discretionary activity, the only certain matters that the council can have regard to when making their decision, and so it really concentrates the arguments for and against to particular matters. And in this case, I've suggested that they're around the Indigenous biodiversity and habitat, because that's what's causing the consenting requirement through these areas. Also, if you're a non-complying activity, if you have one non-complying activity in a bundle of consents, then you end up with all your activities becoming non-complying, and so it's not just the policies within this chapter that then get called into play, it's all of them, which is the case regardless, but it just does open it up, and it is a much higher hurdle to jump over and through in terms of consenting.
Okay. No, that's helpful. I mean, of course, all of this assumes that a regionally significant infrastructure provider decides to progress by way of a resource consent rather than a designation. But I suppose in that scenario, the designation would still seek to point to the policy framework as a consistency proposition in its favour, wouldn't it?
The other thing to note is that Trustpower is not a requiring authority, so they can't seek designations for their activities.
Okay, but you're seeking amendments to the provisions that wouldn't apply just to Trustpower, as far as I understand it. So, I've got to think that one through.
Yeah.
Okay, and I guess the only other question I wanted to ask you is in terms of the Mangorei scheme, are the components designated, or are they all just on land owned by Trustpower and have the benefit of existing use rights?
They're not designated because Trustpower is not a requiring authority, and I believe all the land's owned. As those stocks, is that on?
I believe it's all Trustpower owned land, but I can double check and come back.
I'm just interested, when did Trustpower acquire the scheme?
That's a good question.
I can probably answer that. When the ECNZ was split up in the late 1980s, it put out all these small schemes effectively for tender, and Trustpower as an entity ended up acquiring most of them around the country, these small older schemes, and build a business around those. That's because I was around at that time and did some of that work for them. So
okay, that explains why. So presumably it is there by dint of its historic land use, rather. I mean, obviously I can't see any designations overlaying the infrastructure, so it was presumably one of those transitional approvals that came through the bowels of the Act.
Kat, I think my understanding is that because these hydropower schemes aren't part of a network, they can't have requiring authority status.
Oh, yeah, I get that.
Cannot designate, so there's no designation over them, I think, because there's no ability to do that.
Yeah, well, like I accept that. I'm just interested in the authorizations by which it came to exist, because presumably Trustpower inherited all of those when it acquired the schemes from ECNZ. But look, that's all just a crazy hobby that I have that I won't bore everyone else with. And I guess that was really the only other thing I was interested in with your evidence. But I agree with the chair that the way you've set it out has been very helpful, and appreciate it.
Commissioner Coffin.
I didn't have any questions. The question I did have was in just regards to the regional infrastructure list. I did some homework last night where I went through the RPS to see if there was a list anywhere. There's narratives saying that the port is regionally significant, other things, but there wasn't a list. So
yes,
that's helpful. Thank you.
Yes, and we've certainly been quizzing other submitters, including the regional council themselves, about whether there was a list, and there was some uncertainty about how that all worked yesterday, but now you've clarified that. Thank you. Commissioner McMahon.
I've got a question for Ms. Macbeth and one question for the planner. Ms. Macbeth, I can see where you've dealt with the rule and policy relief that Trustpower have asked for. What about, it's probably here, but I just can't find it. What about the alteration to the boundary of SNA 260? Where's that dealt with in your 42A, or is it not?
Just give me a moment. Have I left it out of the overview box?
I don't know. No, you haven't, because it's in the overview box, page 65.
Okay.
If you go to page 65, the box there.
So it is there?
Yeah, it's SNA 260 trout. You've got it as retained boundaries as notified, though.
Yes.
Well,
that is the recommendation.
I saw those as headings. Grouping relief sort, okay, but they're headings of your recommendations.
Yes.
Okay, but where do you expand on that?
So Appendix 8 outlines all of the site visits undertaken.
Yes, but what about in the text, and where do you talk about?
It would be generally of the, I didn't go into detail of every site visit undertaken.
That's in Appendix 8.
Yes, and it's also within Dr. Herbert's evidence.
Yes. So the recommendation is to retain the boundary.
Yes, it was, yeah, I can confirm that we visited it.
Okay. Yeah, thank you. Okay, I guess, look, I understand everything else, I think. What I'm just looking for some higher order guidance, and is it the MPS REG, or NES? I can't remember if it's an MPS or NES. NPS. It's one of the earlier policy statements, I think, wasn't it?
2011.
Yes. Does it provide any assistance in terms of the relief that you're asking for? I just couldn't see it referenced in your evidence, Ms. Keller.
I would have to look into that further and get back to you.
Yes. I mean, renewable energy generation, is that what Trustpower, is the game you're in?
Yes.
Yeah,
we're renewable
hydroelectric power
generator.
stations, yes.
Yes.
Okay,
We do have one diesel generator.
yes. Okay, if you could come back to us on that.
The reference to the MPS REG is in there's McFarlane Hills evidence, 5.8 and 5.9.
Okay. Thank you.
So the rationale's there as I read it.
Okay. Okay, that was all from me. Thank you for setting out your amendments in colour and appendix in the appendix. But I just note that you haven't done a section 32AA that I could find anyway. So the same matter that we raised with the previous submitter. Sure, the chair would want to comment on that.
Yes, that is quite important to us. So because when any changes are recommended over and above what's been notified, we as a panel have to go through and do the 32AA test, and we are asking practitioners to give us that analysis, working through the various provisions. And as I said previously, the Heppel's Weight, it can be reasonably straightforward. There could be some compelling ways that you give us those changes. So we are required, if we are changing the plan on the basis of submissions made, to make a finding on that. So
is that in relation to provisions or all
yes,
the provisions
modified? New provisions that you're modifying over the top of what's come through from us from the 42A.
Okay.
Because the 42A report does its 32AA on its suggestion, so the blue text. But then if we are going to go beyond that on the basis of submissions we may look to accept, we do need that analysis. And I've been in the position many times as the decision maker of not having that and having to do it ourselves if we do want to change, and that's it's not only tedious, but it's not efficient or effective.
I think what I'd add to that is it helps you try justify the relief that you're seeking, and it helps us if we agree to accept it. But if we disagree, or if we modify it, the compulsion's on us then to alter that 32AA. So there's a tandemness there, if you like.
I appreciate that. Well,
thank you. And just through Ms. Straka, the hearings administrators, and that will get through to us. Now, I do have a couple of questions as well.
I was ready to go.
No, I don't think that'll be too hard for you, but a question of clarification first from Ms. Macbeth. Does the plan use notes, vice notes, as a matter of course?
It does in some situations. Yes.
Okay, so there's no like a lot of some plans to say, look, we're not going there, we're not doing explanations, we're not doing notes, but there's no reason why, as a matter of practice, we couldn't add notes.
We've tried to avoid it. There are some in there, though, aren't there, Denise?
Yes.
Yeah. So we try and get it more in
yes,
as a clause in a rule, but in some situations, notes are used.
Okay. Just as a practitioner, do you like using advice notes? Do you think it's useful? Is it a good practice?
I do find them useful, and quite often an advice note gives some clarification and guidance as to the interpretation.
So don't see it in the same way as those terrible explanatory statements that plans used to have, where you try and work out what was part of the policy or the rule, and did the explanation count or not? So
No, I think it's quite clear. The note is supplementary, and that the policy else is standard.
okay, all right. I had the questions about it's really just about scope. You've added this big long list of regionally significant infrastructures, only one that relates to your interests. Is that, how do we find scope for that?
I think because you already have regionally significant infrastructure wording in the plan, but it's not defined in that it needs definition. Otherwise, it's open to interpretation. So I think it does link into wording that's all present in the plan.
Did the Trustpower ask for the list?
In our original submission, no.
The plan is notified hasn't used the term as far as I know. So in this situation, in this chapter, I've recommended it, and I understand it's possible it's going to come up in other chapters as well. But scope, that is a good matter to raise. Yeah.
Okay. Well, I personally find it quite helpful. It is, as Commissioner Littlejohn said, it seems to be de rigueur at the moment. A lot of that's driven off the NPSFM 2020 around concerning pathways for these sorts of important projects, try and get around the wetland provisions, or not get around them, but have a consenting pathway.
And I think particularly useful where we've got definitions of network utilities, infrastructure, and neither of them quite fit what the role of Trustpower in terms of not being a network utility operator, but having a regionally significant role.
Yes, because the terms infrastructure and network utility was part of the notified plan, but not regionally significant infrastructure.
And I've looked at those two definitions many times. Yeah, and I'm
okay, so scope might be something to discuss. I think those are the main things. Double check. Use the notes. No, your one got off quite lightly in terms of my red pen, so thank you very much. You'll come back to us with the 32 AA. If possible, if that could be done by Monday next week, is that?
Yeah, I'll see what I can do.
Okay. Yes, I suppose we hear when we're talking about the planners conferencing as a possibility, expert conferencing. We've asked Ms. Macbeth to consider whether, before she does her final right of reply, so that will be in about 3 weeks' time, whether it might be helpful to have the planners conference on the complexity of the rules and the different ways of looking at this. We haven't made a direction on that, and we are posing that as an opportunity for people. So I'm just really just getting an indication about whether you'd be happy to participate in that.
Yes, if that opportunity, I'd welcome.
Right. Thank you. Thank you very much for your presentation and for your assistance.
Thank you.
Cool.
It's nearly 3:15. The Trustpower, the Transpower team are next. And then we have Ms. Johnson as well. Is Ms. Johnson here? Oh, there you are over there. Look, I think it's been a long day. I would quite like to have a break for maybe 10 minutes, and we'll start again about 3:20. Thank you. Oh no, good. Thank you, everybody. Sorry for that slight delay. So Ms. McIndoe and Ms. Ratt, are you both on the Zoom, I think?
Yes, Chair, I'm here, and Carolyn is as well. Thank you for taking the time to hear from us. Can you hear me okay?
Yes, you're very, very loud and clear. And sorry, we're just running a little bit late, but the way these things go, there's always a best estimate and best endeavours. Thank you.
And it is always useful as well for us to hear the concerns that have been raised by fellow infrastructure providers. So it wasn't lost time on our part, that's for sure.
I'm pleased about that. Right, you have some submissions for us?
That's right. So I filed legal submissions yesterday. Ms. Ratt has provided evidence and also a summary, which she sent through this morning.
Yes, we have those. Thank you.
What I was proposing to do was to speak to my submissions. I'm not sure. Have you had a chance to read them? Would you prefer if I read them out, or just spoke to them?
We have read everything, so just a highlights package would be great. Thank you.
Okay, thank you. So Transpower has appeared at earlier hearings, and I'm sure you'll have an understanding of its role in providing the national grid. In relation to this chapter, the key concerns relate to the ecosystems and Indigenous biodiversity chapter, as well as the natural features and landscapes chapter. So we're not speaking to matters relating to public access or water bodies.
Thank you.
The Section 42A officer report did address many of the matters which Transpower had raised in its submissions, and so we're just going to focus on the areas of outstanding disagreement, if you like, and those are more fully addressed in Ms. Ratt's evidence. The purpose of the legal submissions was primarily to address some more overarching matters which we thought you might have some questions on. So the submissions talk about Transpower's, why it is that it cares about landscapes and ecosystems, why it is that these chapters are important to Transpower, and its preference that matters relating to the national grid generally are dealt with in the network utilities chapter. So I'll address those 2 points, and I'll leave the description of the actual amendments to Ms. Ratt. Her evidence and summary deals with those. So Section 5 of the legal submissions, I run through sort of why we're here. And I point out that Transpower has assets in an outstanding natural landscape, which is the Sugarloaf Islands. Now those assets are being reviewed at the moment, and they've already been partially decommissioned, and that's ongoing. So we're not necessarily worried about expanding the national grid assets in that location, but do need to be able to continue to operate and maintain those assets. One of the things which Ms. Rebecca Ing pointed out in the strategic directions hearing for this district plan is that the national grid in Taranaki is, if you like, at a state of change. The electricity generation in the region is changing, and the national grid, of course, has to respond to that. So, so while we might have assets in one outstanding natural feature and landscape now, it's possible during the life of the plan that the national grid might need to change within New Plymouth District. So that's the second point that I make in 3.1b. Transpower does typically designate its assets, new assets, And so it does have a particular focus on objectives and policies. Its existing assets don't tend to be designated. It has rights to access them under the Electricity Act. It has a couple of designated lines which were more recently constructed. They're short sections of lines. But Transpower is still interested in the rules, particularly those in the ecosystems chapter, because as I'll go on to describe, there's a need to give effect to the national policy statement for electricity transmission. Transpower can't rule out the possibility of seeking resource consents. It is possible, rather than notifying a requirement for a designation. And while, as I've said, it does have some designations in the district, and in particular its substations are designated, it does rely on the district plan rules for those works which aren't designated. And I've noted there that Transpower jointly manages a line, which is the McKee T line, jointly manages and owns that with Todd Energy, and that line is not designated. So, so the rules are important to Transpower, not just for the lines themselves, but also construction activities and particularly tracks, which it uses to access lines. Sometimes getting consent for the tracks can be harder than getting consent for the lines. So moving along, these rules are also important because of the way the national environmental standards for electricity transmission activities operate. So as I'll explain, particularly regulations 30 to 32 of the NESETA, as we call it, they relate to the trimming and removal of vegetation. And so they cover the same subject matter as the eco chapter rules, and the activity status in the NESETA changes depending on how that activity is regulated in the particular district plan that the works are in. And so it is important to Transpower to think about how the district plan and the national environmental standards would work together. And then lastly, my point G, Transpower also likes to support landowners who need to comply with the electricity hazards from trees regulations. So these are regulations which require landowners in some circumstances to remove or trim vegetation for reasons of electricity safety. And so Transpower, when it reviews district plans, looks to ensure that the rule framework doesn't make it hard for landowners to comply with those regulations. In my paragraphs 3.2 through to 3.4F, I briefly describe the national policy statement for electricity transmission. And I quote the objective. The key points, I think, for this hearing are that it sets out a framework, particularly for the management of effects. And it does that in a general way. So you'll see my description of policies 2 through to 6. Those are general directions, regardless of the location of the national grid asset. And it provides that councils must provide for operation, maintenance, upgrading, consider the constraints imposed on achieving measures to avoid, remedy, mitigate, and require that where there are major upgrades, attempts are made to look to avoid, remedy or mitigate effects through the site route and method selection process, etc. Policy 8 is particularly important though for the NFL chapter, because that includes a direction that Transpower should seek to avoid adverse effects on outstanding natural landscapes. And so that seek to avoid direction is important for Transpower. It's a recognition that it's not always possible to avoid adverse effects of the national grid on outstanding natural landscapes, and Transpower looks to ensure that that is correctly reflected in the district plan documents. Now, in my paragraph 3.5, I talk a bit more about the NESETA. So the NESETA contains rules which apply to operation, maintenance, upgrading, relocation or removal of existing transmission lines, which were the ones existing at the time the regulations were created in 2010. So it doesn't apply to substations, and it doesn't apply to new lines, and it doesn't apply to lines constructed after 2010. So that means it doesn't apply to the Junction Road grid line, which is designated, or the McKee T line, which is the one it jointly managed with Todd Energy, which I mentioned before. So generally, if Transpower's to carry out any of those activities, operation, maintenance, upgrading, relocation or removal, it would look to the NESETA to set out the rule framework for those activities. And the NESETA does contain rules relating to trimming, felling and removing of trees. And it contains a number of conditions which you must comply with in order to be a permitted activity. So it permits those activities unless a rule in a proposed plan or a district plan prohibits or restricts it, or the activity is in a natural area, and natural area is defined as meaning an area protected by a rule because it has outstanding natural features or landscapes, significant indigenous vegetation or habitat. So I guess for our purposes, an ONFL or an SNA. And if you're in one of those locations, then you sort of flows on, there's a controlled activity, and you may well find yourself being discretionary depending on the purpose of the trimming and removal. So it does matter for Transpower that some of its existing lines are in SNAs and outstanding natural features and landscapes. I've summarised that here, and the activity status for Transpower's removal and felling of vegetation will depend on the proposed plan rules, which relate to existing grid lines, as well as, of course, the proposed rules relevant to any new grid lines, because the NESETA doesn't apply to those. Now, the next topic I address in section 4 is Transpower's request for National Grid specific provisions. And here I'm really talking about policies to be located in the Network Utilities chapter. Now, I appreciate that this is not an easy topic because the National Planning Standards also provide some guidance about where matters should be located. So I wanted to cover this subject and give you the opportunity to ask questions about it. So Transpower's preference is that the National Grid specific provisions are located in the Network Utilities chapter, and we will bring evidence and to speak to those for hearing 11. Transpower's submission sorted in the alternative, so stated a preference for the Network Utilities chapter, or if that was not preferred by the panel, that instead the national policy statement be given effect to in each of the individual chapters. So, of course, network utilities are everywhere, and that is one of the reasons why Transpower prefers to have a consolidated regulation of them, particularly in the policy level in the network utilities chapter. It considers that this would be the most efficient approach, primarily for those seeking to rely on them, which is Transpower, as well as council officers who might need to be assessing the applications which might come in for a designation, a notice of requirement for a designation, or an application for a resource consent. There are other provisions which Transpower is supporting relating to the activities of third parties, and it's not suggesting that those should only be located in the network utilities chapter. They will regulate the activities of other people, and there might be other approaches which are appropriate in that situation. But here, where you've got policies which would really only apply to Transpower, its request is that they be in the network utilities chapter. So if just thinking about the alternative, if you were to have the national policy statement given effect to throughout each and every chapter of the district plan, then Transpower would be seeking more nuanced provisions for the national grid in these two chapters which we're speaking to today, as well as those that relate to natural character, historical heritage, sites of significance, water bodies, the coastal environment. There would be quite a lot of repetition. And in other locations, Transpower has found it a lot more efficient to instead have one policy which addresses each of those special locations and provides a direction which covers the things, in particular the things in policies 2 through to 6, which I mentioned before. So the need to consider whether effects have been avoided through site selection, for example, as well as the matters of the MPS, which might be specific to that special location. Now, the national planning standards are somewhat conflicting on this topic. They say that matters relating to network utilities should be in the network utilities chapter, and that things relating to ecosystems should be in the ecosystems chapter, for example. They don't seem to acknowledge that utilities might interact with ecosystems. But the guidance on that is somewhat more helpful. And so I've included a reference to that guidance, which says, which in my view is a little more open, leaving it to councils to do what they think is best. So the guidance says that councils can locate provisions in the energy infrastructure and transport heading unless they're addressed in a special purpose zone. So a port zone or something like that. So we read the guidance as supporting the approach which Transpower is seeking here. Now, there are still instances where Transpower is seeking amendments to the NFL and eco provisions. So you might be wondering, well, if you're leaving it all to the network utilities chapter, what are you doing here? And we are still seeking amendments to the NFL and eco chapters. That's primarily because there's still some tidying up required in our submission, and Ms. Ratt can speak to that. Also, you might find it useful to split the policy direction in relation to the national grid between new assets, which could perhaps more easily be located in the network utilities chapter, we say, or where there are existing assets. And so we've suggested some amendments relating to operation, maintenance, and minor upgrading, which could relate to network utilities generally, and that would be located in the eco and NFL chapters, or it could be specific to national grid, in which case there would be less of a need to address those matters in these locations when you get to the network utilities chapter. So there are different ways to skin the cat, and we've tried to provide some examples and options for you to think about. Right, and just as an example, I haven't put this in the legal submissions, but I did go through and think, what would we need to be changed if you did prefer to address the national grid comprehensively in these chapters, rather than leaving for it to be addressed in the network utilities chapter, what more would we want? And I concluded that we would seek further amendments to particularly policies NFL P2, P3, P5, P6, and to some of the eco policies, and that's also addressed in Ms. Ratt's evidence. So if you did find yourself in a situation where you did disagree and had a clear preference to address the national grid in each of the special chapters, then we would like the opportunity to provide additional drafting of those alternative amendments so that you've got the benefit of those when making your deliberations. But if you like, we're back to horse, and our horse is having these matters dealt with in the network utilities chapter, because that's what we've found works best in other district plans throughout the country. Now, in my sections 5 and 6, I just summarise the amendments which Ms. Ratt's evidence supports, and I just leave her to speak to those matters. That was all I was going to say, but I'm happy to answer any questions.
Thank you very much, Ms. McIndoe. Commissioner Littlejohn is the first batter, I think. So,
look, Nikki, I didn't have any real questions. The one provision I am quite interested in is the request that you've echoed, paragraph 6.1a of your submissions, about including a reference to inappropriate use and development within the eco objective. And gone back, and I've gone back over Ms. Ratt's evidence in this regard, and her evidence is very much just picking up on a similar submission from Trustpower, actually, without a huge amount of analysis, and that's not seen as a criticism, and I'll talk to Ms. Ratt about that. But I'm just wondering, from a statutory point of view, given that this objective is very much seen to be the top of the hierarchy in terms of section 6C and the obligations under that, do you think, what's your support for inclusion of that qualification to the objective when such a qualification doesn't exist in section 6 of the Act?
You're right, of course. It's not in section 6. I'm not familiar with the RPS to the extent which Ms. Ratt is, so she might be able to help you on whether the regional policy statement provides further support for that. The National Policy Statement for Electricity Transmission does provide nothing specific in relation to Indigenous vegetation, but does include a recognition that effects can be managed through site selection, for example, or through considering the effects management hierarchy. And so I read the National Policy Statement as translating section 6 for the national grid. Now, I know that the amendment which we're seeking is broader than just the national grid, and that in reality it's the policies. I was interested in your discussion on this with an earlier submitter, that it's the policies and how they're amended which will, in my view, make a real difference when it comes to consenting. So that's a submission which Trans-Power supports, and I'm going to leave it to Ms. Ratt to expand upon her professional planning view, but from a statutory perspective, there's of course nothing in section 6 to support that.
Presumably the insertion in there is a roundabout way of saying and giving Trans-Power support for the national grid by a roundabout way of saying that, well, the national grid's important, therefore it must be appropriate. I mean, is it that?
I don't think it's quite that simple.
Okay.
I appeared for Trans-Power at the Selwyn hearings a couple of weeks ago, where a similar issue arose actually, and it wasn't at the objective level, and it wasn't in relation to Indigenous biodiversity, so didn't have the section 6 issue. But it's about recognising not just that the national grid can go anywhere, but that where it has tried to go somewhere else, and that has been unsuccessful. So where the other national policy statement policies, which require the consideration of whether effects can be avoided through the site and route and method selection, where that has occurred, but it's still required to go through this area and has an operational and technical need to do so, that might be appropriate. So it's not just about the national grid always being appropriate, it does depend on the context of the location as well. And perhaps that's too fine grained direction to include at the objective level. But but I guess putting the word appropriate or inappropriate in it, the objective allows that to be fleshed out through the policies.
Yeah, I mean, to some extent, the eco objectives at the moment are, they already include a where appropriate, albeit it's protected, and where appropriate enhanced. So it's sort of looking at it in another way. Yeah, okay. Look, I'll take the point up, I think, with Ms. Ratt, but otherwise that was all I really wanted to ask you about. Thank you.
Commissioner Coffin.
It was just regards 4.3 D, where you'd mentioned that there were examples of this. This is in regards to most of the provisions relating to energy infrastructure and transport are in their own particular section. And then in my mind, that kind of makes sense. And I just wondered if you could give some examples that are relevant around New Zealand.
So ones that I've been working on, more familiar with, Queenstown Lakes District Council, and that has a policy which deals with all national grid matters as a national grid specific policy. I've also been working recently on the Wellington Natural Resources Plan, where the courts recently endorsed a consent order, which has a national grid specific policy for regional matters. The Selwyn Plan is a new plan, so prepared under the National Planning Standards, and that in its energy and infrastructure chapter includes policies which are specific to the national grid, including a policy which notes the interrelationship between the national grid and outstanding landscapes. So there are many. Ms. Ratt did look at the district plans directly adjacent, and she can speak to those. I think her summary was it's a bit of a mixed bag because they're quite old plans, your neighbouring plans.
That's fine, thank you.
South Taranaki is a reasonably recent plan, so we'll ask where that ended up. I don't know myself, but we'll ask that of Ms. Ratt. Thank you. Commissioner McMahon.
Yes, thank you, sir. Good afternoon, Ms. McIndoe.
Good afternoon.
Just a couple from me late in the day. Paragraph 4.3D on page 7. This is the sort of dilemma between the National Planning Standards and the MPS. There's reference there to a special purpose zone. Being the exception where you can provide for those rules if it's not provided in the energy infrastructure and transport rules. And I wondered, is there any definition of what a special purpose zone, is that what your footnote refers to? What constitutes a special purpose zone? Would the eco chapter, for example, be a special purpose zone?
Not my understanding of the concept. So I've got the, on my other screen, I've got the guidance up, and it says, you should locate most provisions related to energy, infrastructure and transport under this heading, unless they are addressed in a specific special purpose zone. And then it has brackets, such as a port or mining zone. Right. So that was my understanding, that these eco and NFL ones are natural area zones or natural area chapters, and that port or mining zone are the examples they give in the guidance.
Yes, in fact, the eco chapters really pertain to an overlay of sorts, don't they? The SNA are in a schedule in it, and so is the ONFLs, and they sort of act as sort of mini overlays. Yes. Is there any guidance in relation to overlays in the MPS National Planning Standards?
Well, this one that I'm referred to is one which specifically relates to the structure and chapter standards, but it hasn't. I haven't, and there are equally directions at the National Planning Standard level. I looked at those, which relate to the need to keep the eco matters in the eco chapter. But I'm afraid I can't help you any further.
I don't know the answer either, so I asked the question. Okay, the second and final question just relates to your comment, I think it was in relation to section 5 of your legal submissions, about if there is to be a policy split and wherever wherever these rules land. It might be between new assets on one hand and existing assets on the other. And in relation to existing assets, you said that that would be operation, maintenance, and then you qualified the next term to be minor upgrading. How do we distinguish between minor upgrading and other upgrading?
This is an issue that also comes up. Minor upgrading, is used in the National Policy Statement for electricity transmission. And so that's why, and says that it is something which must be enabled. And then by contrast, the National Policy Statement then talks about substantial upgrades. So minor upgrading isn't defined in this proposed plan. Upgrading is. Transpower would treat minor upgrading as something which is provided for by the National Environmental Standard for electricity transmission activities generally. And that's why I say that perhaps minor upgrading, if you're to deal with anything to do with the national grid in these chapters, then perhaps minor upgrading could be something which is dealt with here, because it's not anything over and above that. Transpower would typically designate or need to get a consent without being able to rely on the national environmental standards. And so that's when it would be looking to that network utilities chapter for a more comprehensive assessment. Now, minor upgrading, I agree, might take some definition. What I've seen other councils do, though, is accept that at the policy level, perhaps it doesn't need to be quite so precise, just as policies refer to other terms which take a bit of interpretation. Perhaps minor upgrading could be used at the policy level, and the rules themselves could then provide greater definition as to what it is which flows from that policy and how that's regulated.
Yes, you agree though that if there's a term in the policy and the rules, let's say related to minor upgrading, it would be important that the meaning under both the policy and the rule was the same, and it had the assistance of a definition in that respect.
Yes, I think it's important that the two that they talk to each other, that the rules flow out of the policy, and so they have the same understanding.
You wouldn't want to disconnect. You wouldn't want to disconnect between the policy and the rule on the one subject.
No, you wouldn't.
Okay, and just finally, you said that if the panel disagreed with having the national grid dealt with in one chapter, then we would need to look at replicating policies in the NFL and the eco chapters, and you limited those provisions to policies as opposed to rules, or that's what I wrote down anyway. Is that what you meant?
Typically, it's the policies that where there's the overlap between what Transpower would seek through a national grid specific policy in the network utilities chapter, and it's the overlap between that and what would otherwise be provided for in policies elsewhere in the plan. At the rule level, Transpower's submissions do assume that the rules throughout the plan apply. And so it's not quite as important because, as I said before, a lot of the time for existing assets, the national environmental standards will apply, although Transpower will designate. It does still prefer that its activities are not characterised as non-complying activities. It likes to be able to have a consenting pathway if in fact a consent is required. But generally it's at the policy level, and it accepts the need that a resource consent or a designation would be required for new national grid assets.
Okay. Sorry, I do have, sorry, excuse me, I do have one final question, and it's in relation to Naseta. Can a plan provision be more onerous than the provisions in the CETA in relation to, say, felling and trimming and removing of trees and vegetation?
Not in this instance. So the RMA does allow rules and plans to be more onerous if the National Environmental Standard says that that can occur. But NACETA